Are you interested in investing in British small and medium enterprises, or perhaps start your own business, and you don't know where to start to get some key information? You have come to the right place. This is the green season of podcasts. It will introduce you to key aspects of the British legal, regulatory and tax regimes. Directed to overseas investors and small business owners, this series of podcasts offers a comprehensive, yet digestible, introduction to the British investment environment. This podcast has been prepared by Dr. Yanis Glinavos with the help of artificial intelligence tools. Get in touch with Yanis by following the information on the description of this episode to learn more about how the podcast was put together. Without further delay, let us get started on the content of this episode. We follow the activities of two inventors, Anna and Conrad, as they are trying to scale up the business. We start by presenting the different forms of business organizations available in the UK. We continue by introducing the notion of a company and presenting the different types of companies that are available. We will then discuss the rights of shareholders and the obligations they have in the running of private limited companies. Let's assume that Anna and Conrad are inventors. They have come up with a novel door ring camera. They have manufactured a few of the cameras in Anna's workshop and now want to start selling them. They are thinking about the best way to go about building a business. Should they start selling as traders, partner up in a formal way, or set up a company? In English law, there is not a great deal of formality required to commence business activity. One could simply produce and sell goods or offer services as a sole trader. This means that someone is entitled to engage in business directly without obtaining permissions from the authorities or registering with the tax authority, the HMRC, in advance of commencing operations for the majority of commercial and retail operations. We will have the chance later in the podcast series to discuss licensing and the personal tax implications of operating a business, but for the moment we can start with the key aspects of operating as a sole trader. The key feature of running a business as a sole trader is that there is no distinction between personal and business finances. The wealth and assets of the person engaged in the business and their personal assets are not distinct and are liable to be spent to satisfy claims by customers, pay costs or settle tax and regulatory charges. The ease of doing business under one's own name therefore is counterbalanced by the danger that any liabilities attaching to the business also attach to the person running it. In more technical terms, we could say that operating as a sole trader offers no limitation of liability and no legal firewall between business and personal finances. It is precisely this feature that leads the majority of entrepreneurs to select other, more structured forms of business organizations through which to pursue their business activities. English law provides two main vehicles for pursuing a business for profit: companies and partnerships. We can begin advising Anna and Conrad by explaining what the meaning of these terms is. The term company normally implies an association of a number of people for some common purpose, but a single person can also form a company. You should not be left with the impression that companies are only suitable for large groups of persons coming together. The EU has put the matter beyond doubt with the passage of the 12th Company Law Directive. The purpose of a company will normally be of an economic nature. We are normally thinking of companies as businesses. The law on partnerships has different origins and is largely contained in legislation dating from the 19th century. This form of business organization is based on the idea that each partner becomes an agent of the other and can therefore act to bind the partnership. Therefore, partnerships are normally suitable vehicles for small numbers of people who have trust and confidence in each other. There is also an assumption that the partners remain stable. Note that there are tax advantages to different forms of business organization that will affect partnerships and companies differently. Tax concerns will affect the choices someone in the position of our inventors Anna and Conrad will make. Companies are commonly chosen as the appropriate form for larger associations with fluctuating membership. Such elements require that a corporate personality is created for the company distinct from that of its shareholders. The company becomes a separate legal person. The law governing companies is largely contained in the Companies Act of 2006. One of the key differences between companies and partnerships is the presence or absence of limited liability. Limited liability means that shareholders are not liable for the debts of a company. They only stand to lose out money they already invested by buying shares. No loss accrues to them beyond what they have already invested if the company fails. Companies can have limited liability, while a standard partnership does not. Partners share in profits and debts equally. However, a hybrid form of business was introduced by the Limited Liability Partnerships Act 2000. This statute enables the creation of a limited liability partnership, LLP. This LLP is in fact a lot closer to companies than it is to traditional style partnerships. An LLP has separate legal personality and limited liability, like a limited company, but for tax purposes and in internal decision-making process, it operates like a partnership. In other words, there is no separation between the roles of partner, member, and director in an LLP, and its members have freedom to decide on their internal decision-making structures. The LLP has proved successful for professional services businesses, for example solicitors. We have assumed so far that Anna and Conrad want to run a business and have a profit-making motive. But let's assume for a moment that the inventors are not really interested in money, and their main aim is improving home security for the benefit of the wider public. What if they want to make their product available for free, or at cost to save the planet and their country? If their aim is one public interest, but they do not want to set up a charity, Anna and Conrad could set up a community interest company under the Companies, Audit, Investigations and Community Enterprise Act 2004. Community interest companies, CICS, are limited companies, with special additional features, created for the use of people who want to conduct a business or other activity for community benefit, and not purely for private advantage. This is achieved by community interest test and asset lock, which ensure that the CIC is established for community purposes and the assets and profits are dedicated to these purposes. Registration of a company as a CIC must be approved by the regulator, who also has a continuing monitoring and enforcement role. This is a useful vehicle for purposes which do not fall under the legal definition of charitable purposes, and they are in the public interest, or alternatively they are of private interest, but do not seek to result in profit, for example tenants' association for the maintenance of a building. Of course, if our inventor aims come under the definition of a charitable purpose, then they could register a charity, charitable incorporated organization, under the Charities Act. One of the key features of companies is that the liability of their members can be limited. This means that the shareholders are not liable for the debts of the company. There are two means via which liability can be contained. One is to create a company limited by shares, the other by guarantee. Tauhe Companies Act does not permit a company to be formed where its members are completely free from all liability. The most common way to limit liability is to set up a company with its capital divided in shares. Each member purchases some shares. The money they spent represents the total commitment to the business. If the business goes under, they cannot recoup the value of their investment, but if the company leaves behind debts, the creditors cannot come to the shareholders and ask them to pay up. A similar way of achieving the same result is to limit liability by guarantee, popular for charitable, quasi-charitable organizations like schools and supporters Friends of Arts and Museums. A guarantee binds members to an agreement that in the event of liquidation they will, if required, pay up to specified amount. People may wish to have a company limited by guarantee as a less complex alternative to setting up a trust. Why prefer not have shares? If the purpose is not to make a profit, and therefore not to divide up this profit to the members, there is no purpose to having shares, one of the main attributes of which is the payment of dividends. Also, the guarantee does not require that anyone puts money up front. A guarantee only activates when things go wrong, as opposed to shares that are normally fully paid at the point of registration. One consequence of limitation by guarantee is that one can leave the company by resigning. In a company limited by shares, on the other hand, one cannot resign a share but needs to find someone to transfer it. We also need to address the fundamental distinction between public v. private companies. There are many characteristics that companies can have that sometimes overlap, but often do not. When people are asked what they know about companies, they will normally mention the concept of limited liability and the ability to offer shares for sale to the public at large. There is a lot of talk of a shareholding democracy, for instance, the idea that the public can participate in the success of capitalism at home and abroad. It is not necessary, however, that a limited company is a public company, and even if it were, it is not necessary that a public company offers its shares in a stock market, like London Stock Exchange, LSE. All these are important distinctions for a series of reasons. The treatment under the Companies Act in some respects differs, and also the stock exchanges have a myriad rules that they apply to their listed companies. How would Anna and Conrad select from all these options? We have already discussed that our inventors will need to think about whether they want a company, whether that company should be limited or unlimited, and what type of limitation, by guarantee or shares, they want to go for. If they opt for a limited company by shares, should it be a private company or a public one? The key thing to know is that private companies are not allowed to offer their shares to the public. This includes an offer that can result in people acquiring shares outside those contained in the offer. What is the meaning of private in this context? A private company is one where someone is already connected with the business. Connected persons with the company are members, employees, family, debenture holders, creditors, trustees. Public companies bring in any member of the public that wishes to purchase shares in the business. They are as a result more tightly regulated. The regulatory framework for public companies is not only in the Companies Act, but also in the Financial Services and Markets Act 2000 and Financial Services Act 2012. Still, English law does not have separate mechanisms to distinguish between the two, like in some continental jurisdictions. Even if Anna and Conrad opt for establishing a public company, it is not necessary that its shares will be traded at an exchange. A public company and a listed company are two different things. Statutory created bodies will create several regulations, and the stock exchange rules will all apply in different ways to publicly listed companies. For instance, a company wishing to have its shares traded in the LSE will need to have them admitted to the official list of securities, maintained by the FCA in its capacity as UK listing authority. UKLA regulates entry to the stock market in the interests of protecting shareholders through the release of information about the company. Further, stock market rules govern the company's conduct after listing. These contain provisions on related party transactions, significant transactions, and more that supplement provisions in the Companies Act. Also, these rules provide the legal basis for the UK Corporate Governance Code, a set of best practice guidelines that inform the behaviour of boards in public listed corporations at the LSE. The focus of this episode is small and medium-sized enterprises. We will focus therefore on aspects of shareholding for private limited companies, or LTDs. The key feature of incorporation as a private limited company is for its owners, the shareholders, to benefit from limited liability. The idea, as we discussed above, is that members of the company, shareholders, are not responsible for the debts and other obligations of the company. The doctrine of limited liability therefore shields shareholders from personal liability as long as the company is a going concern, and from the debts when the company goes insolvent. Liability can only remain in relation to any non-paid shares at the nominal value or guarantees if the company is one limited by guarantee. The rationale for limited liability is that it encourages investment from intercompanies by buyers of their shares. At the same time, however, it discourages loans to the company, as the creditor's chance to recover the loan depends on the financials of the company itself, as opposed to its members. Because of incorporation and the associated doctrine of the company's separate legal personality, a company can own property, sue and be sued. Crucially, a company, being a legal creation, is perpetual and is not affected by the physical death of any of its members. A great benefit of incorporation is the transferability of the company's shares to new owners. In the absence of any provision to the contrary in the company's constitution, shares are freely transferable, and someone can stop being a shareholder simply by transferring their shares to someone else. Note, however, that a private company cannot offer its shares for sale to the public, but transfer is still possible, while public companies can sell to whomever. Private companies therefore have determined shareholders. They are the ones who set them up. And in those there is normally no separation between ownership and control, as the same people tend to be shareholders and directors. As the relationship between shareholders in a public company is essentially impersonal and financial, there is usually no reason to restrict changes in membership, and usually shareholders and directors are distinct. Management under a board structure is another advantage of incorporation. Shareholders do not need to be directors, tasked managing the company. They can indeed do very little. It is in fact believed that a business is run most efficiently when control and cash flow rights are vested in the same party, or, when they are vested in different groups, if there is a clear definition of the rights and responsibilities of the respective parties. An example would be where control rights are vested in management and cash flow rights vested in shareholders. In large companies, separating ownership from control is essential in securing liquidity, as investment is needed from multiple sources, at substantial levels, and all shareholders cannot reasonably be expected to participate in every day-to-day management decision. How companies determine their management structures is up to them. There is considerable freedom in this respect in English law, but in the case of listed companies, a lot of guidance is provided by the Code on Corporate Governance. The UK Corporate Governance Code sets out standards of good practice in relation to board leadership and effectiveness, remuneration, accountability, and relations with shareholders. All companies with a listing of equity shares in the UK are required under the listing rules to report on how they have applied the code in their annual report and accounts. The code contains broad principles and more specific provisions. Listed companies are required to report on how they have applied the main principles of the code, and either to confirm that they have complied with the code's provisions or, where they have not, to provide an explanation. The idea behind this arrangement is that companies determine how they are run, and then the law steps in to determine how those with the power, privately allocated, get to exercise it, for example, how the directors perform their functions. The most important document in regulating the company's behavior is its Articles of Association. The Companies Act defines the Constitution as including the Articles of Association, but not limited to them, any special resolutions, or shareholder agreements. The legal status of the Constitution is contractual in nature. Tauhe provisions of the company's constitution bind the company and its members to the same extent as if there were covenants on the part of the company and of each member to observe it. This means that the constitution works as a multi-party contract between the company members and members with each other, therefore there is no privity problem in the acquisition of rights. Unlike a contract, however, the constitution is a public document. The articles are a public document, either because they are based on the statutory models that are already public, or because the company supplies to the registrar for public registration its own documents. Publicity of the articles is a traditional requirement in English law and also a requirement of European law. The articles, even though contracts at core, they are not interpreted exactly in the same way as normal contracts. The reason for this is the expectation that the articles give an accurate impression of what the company's managing mechanism is, in a way that is obvious to third parties. The courts therefore cannot imply terms into the articles, in the way that they would into contracts to give effect to the intentions of the parties. Similarly, the articles are not defeasible on the grounds of misrepresentation, mistake, undue influence or duress. As we mentioned above, a great deal about the company's running is left to be determined by the company itself, and the result of this determination is reflected in the articles. They will deal with matters such as the division of powers between shareholders and the board of directors, the composition, structure and operation of the board. As the shareholders control the constitution of the company, then they are the ultimate source of managerial authority within the company, and the directors obtain their powers by a process of delegation form the shareholders. Parties to the contract can enforce obligations contained in the articles. Parties to this contract are the members of the company. The directors of the company, in their sole capacity as directors, and not also shareholders, cannot therefore enforce obligations in the articles. A member therefore can enforce obligations only if they confer a benefit to him as a member at the relevant time. A third party who subsequently becomes a member does not acquire standing to sue on pre-existing obligations. An outsider to whom rights purport to be given by the articles in his capacity as an outsider cannot sue on those rights, treating them as contracts between himself and the company if he subsequently becomes a member. Subsequently, only if a director has a separate contract with the company can he expect to be compensated. For instance, reference to compensation in the articles does not constitute contractual entitlement. The Companies Act facilitates the process of drafting the articles by offering model articles of association for different types of companies. Model articles will apply to all new companies incorporating under the Companies Act 2006. These can be accessed on the Companies House website and via relevant legislation. Of course, regardless of whether the model has been adopted fully or personalized, subsequent amendments are possible. The articles normally specify a procedure whereby amendments can be made. A two-thirds majority of members can then alter the articles by following this procedure. The law protects the minority in two key ways. 1. The consent of an individual member is required for any increase in liability, obligation to subscribe for more shares. 2. Shareholders can entrench provisions of the company's constitution and make them subject to special procedures before amendment. Another way of altering company behavior, without amending the articles, is in the form of shareholder agreements. The advantage of those is that they can remain private and do not need to be registered in Companies House. On the other hand, as private agreements, they do not bind parties beyond them. There are different types of shares that a company can issue. A key lever in understanding the functions of shares is to remind ourselves that shares are property rights. As such, members do not have to vote their shares with the interests of the company in mind. They can do as they wish with their property, which translates as, they can vote for their personal interests even if these are at odds with the company's interests. Ordinary shares are those without any attributes to distinguish them from the rest. Ordinary shares are a very flexible form of finance for a company because they entitle shareholders to no specific level of return by way of dividend, while shareholders cannot withdraw their contribution without the company's consent at issue, redeemable shares, or via an offer to repurchase on a later date. Some controversy exists on whether shares ought to be treated as property rights, or whether they should be perceived to be investments, and as such primarily bundles of contractual rights. The position in English law veers towards maintaining the share status as proprietary rights. The value that the company receives may represent less, however, than the total value of its assets, as the company can raise money from sources other than the shareholders, e.g., by borrowing from a bank. Even if it has not yet started trading, if it has started trading, the company's accounts will contain any profits over and above loans and share value. Value beyond that contained in the shares is not part of the company's capital. The reason for this is that all assets are transient, and the shares are the core of the value that exists to satisfy creditors if things go wrong. Despite the importance placed on the value of the shares, as the company's capital, however, English law does not heavily regulate minimum capital. Only public companies need to have that minimum, currently set at £50,000. This requirement came from the EU's Second Company Law Directive. Obtaining the minimum capital is a condition for getting the trading certificate for a public company, therefore it is a very significant requirement. If a company has started trading without the certificate, it is liable to a fine, as is any of its officers in default. Third parties, however, are protected, in the sense that any transactions entered by the company are valid, but if the company fails to comply with its obligations, the directors are jointly and severally liable to indemnify any losses suffered by the third party. When a company is formed, a company limited by shares, the application for registration must contain a statement of capital and initial shareholdings, the total number of shares to be taken on formation by the subscribers to the Memorandum of Association, their nominal value, the particulars of the rights attached to the shares, the number of shares taken by each subscriber, and the amount immediately paid up for the shares. Often this will be 2 shares of £1 taken by 2 people upon which nothing is yet paid up, as the subscribers are the employees of a company that promotes companies and what they are doing is just setting up a shell company. When more substantial numbers of shares are issued subsequently, information needs to be given to the registrar, return of allotments, and data needs to be provided about those who got the shares, rights and obligations attached to these shares, classes of shares. All this is public information. This, of course, is only a disclosure obligation, not a state control as to what the company should actually do. Shares not only represent an ownership stake in a company but are also sources of income for shareholders in the form of dividends and distributions. What is a distribution? The most common form is the yearly or twice-yearly payment of a dividend by a company to its shareholders, usually in cash, but sometimes with additional shares. The law sets some rough limits on the ability of the company to distribute its profits to its shareholders. For example, company cannot distribute value if its net balance is negative, and it cannot distribute profits if that means that its net value will fall below its legal capital requirement. So long as the company respects that basic framework, it is free to deal with its excess funds in whichever way it wishes, reinvest, or give it back to shareholders. Such payments can be very significant. The reason for handsome payouts is that the company is owned by the shareholders and this is how they recoup their investment. We are used to consider shares in a purely transactional manner, buy low, sell high. This is only relevant to public listed companies, and a lot of shareholders keep shares in private companies to benefit from the income generated via dividends and distributions. The internal procedure for authorizing such payments will be detailed in the Articles of Association. The model articles require both a recommendation from the board and shareholder approval. The shareholders, however, are not permitted to approve a level of dividend above that recommended by the directors. The issue of how companies can be managed in an effective way and what the role of law is in assisting this to happen is a crucial question of company law. The result is a developing literature on corporate governance that seeks to address command and control issues for big corporations where the shareholders are very much distinct from the board of directors, which itself may be distinct from professional managers who run the firm's day-to-day operations. How the whole system comes together and the relationships between the constituent parts of the corporate organization is part of an expanding literature. The larger a corporation gets, and the more diverse its shareholding, the more difficult it becomes for shareholders as a body to manage the firm. Therefore, effective management is promoted in English law by including provisions in the company's articles of association giving the board of directors extensive power to manage the company's business and to exercise its powers. Who are the directors supposed to run the company for? The director's primary accountability is to the company's shareholders, up to the point of insolvency, when accountability to the creditors becomes the primary focus. There are, however, as we will see, other groups that have a connection to the company, other stakeholders, as they are called. A development of a doctrine of corporate social responsibility implies obligations to groups outside the firm's shareholders, to people like employees, the community, the nation, the environment. There are some areas of decision-making that the involvement of the shareholders is mandatory. The general meeting needs to approve the board's decision. These are alterations to the Articles of Association, changing the type of incorporation, decisions to issue shares, decision to repurchase shares, reduce capital, give financial assistance, private companies, alterations of class rights, voluntary winding up. For public companies, the general meeting has to participate in the appointment of auditor, certain transactions entered into by the directors with the company, taking of corporate opportunities by directors, defensive measures in case of takeover bids, and approving transactions beyond certain size, exceeding 25% of the company's assets, profits or capital depending on the circumstances. Last, but not least, the general meeting can always with an ordinary resolution elect to dismiss the board of directors. This episode has focused on investing in small and medium enterprises. We presented the different forms of business organizations and discussed what is a company and what types of companies there are. We also saw some key information on shares in private limited companies, how one attains them and what they are for. We also got to meet our starling inventors, Anna and Conrad. Considering the material presented in this episode, what should we advise them to do? The best outcome for our two inventors would be to set up a private limited company. We can call their new business Anna Con Limited. Anna Con Limited will offer Anna and Conrad a predictable structure through which to arrange both relationships with each other and to arrange the relationships of the business with third parties. The Articles of Association will offer security to Anna and Conrad that they have defined roles as shareholders and in all probability directors of their company. The articles will also provide mechanisms for making decisions and navigating through arguments and disagreements. Having assigned roles also will offer clear lines of accountability. Ownership through shares will allow the distribution of benefits as the business grows and generates profits. Finally, and crucially, the selection of a private company limited by shares as the preferred mode of business organization will separate the personal assets of Anna and Conrad both from each other and from the outside world. The financial and tax affairs of Anna Con Limited, the business will be distinct from those of its owners and managers. Alternate structures, like a partnership, can only offer some of the above aspects, especially in the area of limitation of liability and working without the benefit of anything formal, as a sole trader would do, would certainly create more trouble for our partners than it would solve. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about costs and procedures of company setup, communications with the relevant authorities, and present the obligations of company directors at the initial stages of the life of a new company. Without further delay, let us get started on the content of this episode, which focuses on the process of setting up a new company in the UK. This episode presents the necessary stages one needs to go through to set up a private limited company and describes the documentation required. We start by recapping the endeavor of our inventors Anna and Conrad and proceed by discussing costs and procedures, communications with the relevant authorities, and conclude with an introduction to the obligations of company directors at the initial stages of the life of a new company, touching on the core of communication obligations with Companies House. In our previous episode, we were introduced to inventors Anna and Conrad. They both believe that the door camera invention will make them rich beyond their wildest dreams, and they are thinking about the best ways to go about exploiting the potential of their product. Of course, if Anna and Conrad want to make this product a gift to the world, they could consider if they want to set up a charitable company, or they could consider a community interest company. If they decide that a company is a good vehicle for this purpose, they will still need to consider the following. Should they go for a limited or an unlimited company? To summarize, an unlimited company does not distinguish between the assets of the company and the assets of its members. The shareholders therefore are subject to liability for the debts of the company without a cut-off point. Why would anyone therefore choose to have an unlimited company? Maybe one does not need the feature of limited liability. If one sets up a consultancy, for instance, to offer teaching at universities on specialist matters on a sessional basis, then there is little risk that such company will incur debts or risk liabilities of the professional negligence variety. There are in fact a few advantages to an unlimited company. It can return capital to shareholders more easily than its limited sibling. The prohibition against a company acquiring its own shares only applies to limited companies, for instance, and there is no requirement to make public information on the company's financial position. The absence of limited liability may even make the company appear a safer investment in certain industries and would eliminate the need for guarantors if the business were to seek bank loans. If Anna and Conrad opt for a limited company, then they have the following choices open to them. Should their company be limited by shares or limited by guarantee? As we saw in the previous lecture, a guarantee only activates when things go wrong, as opposed to shares that are normally fully paid at the point of registration. One significant consequence of limitation by guarantee is that one can leave the company by resigning. In a company limited by shares, on the other hand, one cannot resign a share but needs to find someone to transfer it to. Once they have decided on the type of limitation, they should also consider whether the company should be a private or a public one. The choice has to do with what economic purpose the company serves. Public companies raise finance from the public at large, while private companies rely on a limited initial investment from a defined number of people. Companies usually incorporate as private and may become public at a later stage when the company needs influx of investment to grow. If a company wants to register as public initially, they will have to comply with more complex incorporation requirements. The name of the company is very important, as a company becomes an independent creature with its own legal personality, separate to that of its owners and managers. The name has huge marketing significance. If Anna and Conrad opt to set up a private limited company, on the application for registration they will need to state the company's proposed name, so that after incorporation they can give adequate publicity to their business venture. To market effectively, the name should be something short and well considered, as a change of name is a complex process and one that is bound to confuse and alienate customers. In fact, a maximum of 160 characters are allowed. If the company is to be limited, then the name must end with the suffix limited or public limited company. Could Anna and Conrad pick absolutely anything as their company's name? The short answer is no, as there are restrictions, controls and requirements for approval of certain words and expressions when used in a company name, rules on punctuation and permitted characters, sensitive words and expressions. There are also rules on name endings depending on company type. Names that imply a connection with any part of government are not allowed. In order to make a selection, Anna and Conrad will start by going through a process similar to what is known as search engine optimization, whereby one searches for certain keywords to see what comes up on internet search engines. For company names, this is best carried out through the company's house. This service ensures that our inventor's chosen name is not the same as an existing name on the index of company names. Anna and Conrad should also check the trademarks register of the UK Intellectual Property Office to ensure that the proposed name does not infringe an existing trademark. Let us take our inventors through this process, step by step. As mentioned already, Anna and Conrad are not completely free to choose any name they want for their proposed company. If their company is to be a private company limited by shares or guarantee, its name must end with Limited or Ltd. If they opt for a public company, straight away, its name must end with Public Limited Company or PLC. Legislation sets out the controls and restrictions on the choice of company name. There is a requirement that certain expressions and abbreviations which describe a particular form of company can only be used at the end of a name, such as Public Limited Company or Community Interest Company. There are rules which prevent the registration of a name which is the same as an existing name on the index. There are also controls over the use of certain characters, signs, symbols and punctuation in a company name. As mentioned already, names that suggest a connection with His Majesty's government, a devolved government or administration or a specified public authority are not allowed. Names that include sensitive words and expressions included in regulations, and names that include words that would constitute an offence and offensive names are also excluded. It is worth exploring further what is meant by same as. If two company names are so similar, they are likely to confuse the public as to which company is which, then they are the same as. To determine whether a name is the same as an existing name, Regulations set out the words and expressions that must be disregarded and the words, expressions, signs and symbols that are to be regarded as the same. For example, designated name endings, including permitted abbreviations, are not considered when examining similarity. Certain words and expressions are also excluded from consideration. These include biz, co.uk, com, company, UK, United Kingdom, net, org.uk, services, international, blank space between or after a word, expression, character, sign or symbol, and punctuation. The consequence of these rules is that one can register a domain name as a company name. The registrar will not reject it for containing a URL. Some words and expressions will be regarded as the same as, preventing people from easily circumventing the rules. For example, and, the and sign, plus, and, the sign plus, the number 1, and, the word 1, etc. are considered the same. There are, however, some exceptions to the same as rules. The rules do not apply when the proposed company will be part of the same group as an existing company, and the existing company consents to the registration of the proposed name. The application to register will need to include a statement from the existing company which confirms its consent to the incorporation of the new company name or that it will form part of the same group. Certain words and expressions cannot be used as part of a company name. This is to avoid the situation where a phrase included in a company or business name could suggest business preeminence, a particular status, or a specific function, imply a connection with a government department, devolved administration or public authority, or cause a criminal offense. These rules are in place to protect the public from being misled. There are a list of such sensitive words in the company, limited liability partnership and business names, sensitive words and expressions, Regulations 2009, SI number 2615. Also see the company, limited liability partnership and business names, public authorities, Regulations 2009, SI number 2982. Even if Anna and Conrad adhere to all these rules and select a name that they believe to be appropriate, they could still be required to change their company name after incorporation if the name is too like an existing name on the index, misleading information was provided at the time of registration, the company's activities are misleading, the company no longer justifies omitting limited from its name, or the name is too similar to a name in which someone else has goodwill. They could be directed to change their company name within 5 years of incorporation if misleading information was provided to enable the name to be registered or if an undertaking or assurance given to enable the adoption of the name has not been fulfilled. A typical example would be a company whose name and stated activities suggested it was providing training courses that the public believed would lead to a recognized qualification. Whether a name is too like another is a similar, but not the same test as the one we encountered before in relation to same as names. In general, a name is too like an existing name if the differences are so trivial the public are likely to be confused by the simultaneous appearance of both names on the index, and/or the names look and sound the same. Names that differ by the inclusion of additional words, as opposed to a few characters, will not be treated as too like, regardless of whether the additional word does or does not describe an activity in detail. However, names that differ only by the inclusion of words that are normally associated with a name ending such as company or partnership will be regarded as too like. When choosing their proposed name, Anna and Conrad should check the index to ensure it will not result in an objection for too like, which could require them to change their company name. Not all too like names result in an objection but could incur additional costs, for example, new signage, business stationery, and also damage to the goodwill you have gained since incorporation. It is also worth noting that English law does not allow opportunistic registrations. This is unlike domain name registrations, for example, where the first person to claim the name owns it. Opportunistic registration is the term applied to a company or LLP which registers a similar name to one in which another person has goodwill. There is no restriction on who can complain. Complaints about opportunistic registration are handled by the Company Names Tribunal, not Companies House, which provides a remedy for parties who suffer damage by the registration of a company or LLP name in which they have a goodwill reputation. Objections are also based on the suspicion that the name has been registered in order to extract money or to prevent the aggrieved party from registering the name. Anna and Conrad should be aware of the difference between their company's name and a business name. A business name is any name under which someone carries on business other than their own. In the case of a company or limited liability partnership, it means a name that is not its registered name. In the case of a sole trader, it means a name other than a surname with or without forenames or initials. In the case of a partnership, it means a name other than the partners' names. Business names are not registered under the Companies Act, but some of the rules included in the Act do apply, principally restrictions on the use of certain words in the name and names that could imply a connection with a government department or public body, inappropriate and misleading use of a name ending, e.g., limited, at the end of the name. As we have seen earlier, there are rules to prevent the use of names that could mislead the public, and additional rules requiring the names of sole traders and partnerships using a business name to display it on stationery and signs at business premises. Once Anna and Conrad have selected the company's name and are ready to proceed with their registration application, they should be made aware of how they must publicize information about their new company. Regulations made under the Companies Act 2006 require a company to display its name at its registered office and other places of business, on business documents and on websites. The purpose of the regulations is that the legal identity of every company should be revealed to anyone who have, or may wish to have, dealings with it. Every company, unless it has been continuously dormant since incorporation, must display a sign with its registered name at its registered office, any inspection place, at any location at which it carries on business, unless it is primarily used for living accommodation. It must also include its registered name in all business communications, hard copy and electronic. If Anna and Conrad open a physical office or shop, they will need to display a sign with the company name in characters that can be read with the naked eye, in such a way that visitors to that office, place or location may easily see it. They must also include the company's registered name in all forms of business correspondence and documentation, whether in hard copy or electronic, including business letters, notices and other official publications, business emails, checks purporting to be signed by or on behalf of the company, bills, invoices and other demands for payment, receipts and letters of credit. The company name must also be displayed on the business website. While there is no need to include the company name on every page, it must be displayed so it can be easily read. There are also a number of other items of information that a company must communicate to the public. A company must display, key amongst other required information, on all its business letters, order forms and websites the part of the United Kingdom in which the company is registered, the company's registered number, the address of the company's registered office, if a company is exempt from the requirement to use limited in its name, the fact that it is a limited company. If anyone with whom the company deals in the course of business makes a written request for the address of its registered office, the address of any place of inspection, the type of company records kept at the registered office or inspection place, the company must provide this information, in writing, within 5 working days. It is not necessary, however, for the company to state the directors' names on its business letters unless it chooses to do so. Nevertheless, if it does decide to include the names, then it must state the names of all its directors. In other words, a company cannot be selective about which directors' names it shows, it must show all of them or none of them. To incorporate their company, Anna and Conrad must file the following documents: an application to register a company, Form IN01, and pay a fee of £12 for an online application or £40 for a paper one, submit the Memorandum of Association, Articles of Association, and additional information if their choice of name includes a sensitive word or expression. Checking carefully existing names and the rules we discussed earlier on name selection is very important, as it is not possible to reserve a name. The application to register a company, Form IN01, requires the following information: the proposed company name, the location of the company's registered office, it may be in England, Wales, Scotland or Northern Ireland, the address of the registered office, whether the company will be private, public or unlimited, choice of articles of association, details of the proposed directors, and the company secretary, if there is to be one, the director's service and residential addresses, a statement of capital and initial shareholdings or a statement of guarantee, notification if the proposed name contains a sensitive word with the confirmation that the views of a government department or other body have been requested, and finally a statement of compliance or guarantee. Anna and Conrad will also need to select a relevant SIC code for their business. This is the Standard Industrial Classification of Economic Activities Code. A condensed list of SIC codes for providing a description of a company's nature of business is offered by Companies House. The Memorandum of Association confirms the subscriber's intention to form a company and become members of that company on formation. In the case of a company that is to be limited by shares, The memorandum will also provide evidence of the members' agreement to take at least one share each in the company. Under the Companies Act 2006, the memorandum is a much shorter document because all the constitutional rules of the company are contained in the Articles of Association. Consequently, the memorandum serves a more limited purpose, and once the company has been incorporated, it cannot be amended. The required memorandum wording is included in the Company's Registration Regulations 2008, 3014, and Anna and Conrad must use this format when preparing their memorandum. As we have seen in our previous episode, the company's Articles of Association are its internal rulebook, chosen by its members. Every company is required to have articles, which are legally binding on the company and all of its members. The articles help to ensure the company's business runs as smoothly and efficiently as possible and will set out how decisions are taken by the members and directors as well as various matters connected with the shares. The articles cannot contain rules that are against the law. Provided the members observe this general principle, they have complete freedom to choose which rules are included in the company's articles, although they may find it convenient to rely on model articles as a default position. On incorporation, a company can adopt model articles in their entirety, model articles with amendments, or it can draft its own bespoke articles. What if Anna and Conrad want things very simple and are in a hurry to start their business? With new online submissions of documents, it is very fast to set up a company. In earlier eras where things were more time-consuming, a popular method to start a business fast was to buy an off-the-shelf company. One that is pre-incorporated and then make amendments to its articles and name as appropriate. You may have encountered the terms off-the-shelf company and shell company. An off-the-shelf company is one created by a company formation agent, known as promoter in English law, and held as dormant, pending onward sale to a new business or to a sole proprietor or partnership wishing to become a limited company. A shell company is a company bought off the shelf with nominee directors standing in front of whoever really benefits. When the incorporation process is complete, the registrar will issue a certificate of incorporation stating that the company is incorporated, giving its name and registered number, information on the date of incorporation, whether it is limited, whether it is public or private, and the jurisdiction in which its registered office is located. The effect of incorporation is that the members specified in the memorandum become the holders of the shares specified in the statement of capital, and the directors and secretary are appointed to their offices. The registrar decides whether to incorporate a company or not, and this is an administrative function subject to judicial review. However, once the company is incorporated, then its creation cannot be undone, as the certificate is taken as conclusive evidence of the company's existence. According to the Companies Act, this is all that is needed. A private company can begin to trade. A public company, on the other hand, is subject to some further requirements. A public company needs to obtain a further certificate of trading. This document certifies that the company's allotted share capital is not less than the required minimum, currently £50,000. A private party therefore cannot challenge the act of incorporation, but the Crown can, usually on grounds of public policy. Only the Crown can plead the nullity of a registered company. A company therefore exists, even if it suffers from some flaw of incorporation. The correct action to take in resolving a problem is to wind up the company. This is done to protect people who may have dealt with the company on the strength of the registration certificate. Finally, it is worth mentioning that Anna and Conrad could register for corporation tax when going through the steps of registering their company. Most companies register for corporation tax and pay as an employer at the same time as registering with Companies House. We will discuss details relating to tax in our following lectures. A company, as a legal fiction, needs the intervention of a human agent in order to come about. The persons tasked with creating or helping to create the company are called promoters. The expression promoter covers any individual or company that arranges for someone to become a director, places shares, or negotiates preliminary agreements with potential company members and third parties. Usually this is someone involved in the creation of the company, but this is not necessary. It could be that it is someone who subsequently helps to arrange the floating of the company in a stock market, most usually staff in an investment bank. Because there are many possibilities of abuse of the promoter's position, as they usually sell the company their services, or their business, before the company has independent decision-making structures, the courts have concluded that anyone in this position stands in a fiduciary position towards the company with all the duties of disclosure and accounting which that implies. A promoter is prohibited from making any profit out of the promotion without disclosing it to the company. Further, the law mandates that promoters are under a duty to ensure that the company has an independent board of directors and to make full disclosure to it, so that the board can exercise an independent and intelligent judgment on transactions. It is also possible that disclosure to those becoming members of the company is considered equally effective. Nevertheless, this carries the risk that the promoter discloses information to people they are already intimately connected with, and those are not likely to object if they are all participant in transactions aiming at personal, as opposed to corporate, enrichment. The legal position therefore is that disclosure needs to be made to the company, meaning to an entirely independent board, or to the existing and potential members as a whole. Further, the disclosure needs to be explicit. When a transaction generates a profit for the promoter, then the promoter as trustee needs to pass such profit on to the company or disclose any proposed profits and inform the company of its right to value the property at its cost price. However, when the promotion of the company involves offering shares to the public, then explicit disclosure requirements are set by legislation. If the promoter breaches his duties, then the remedy is for the company to bring proceedings for rescission of any contract with them or for the recovery of any secret profits which the promoters have made. The flip side of all these rules is that the only way a promoter can be paid for their services is if they have a contract with the company to that effect. The weakness with this is that the company before incorporation cannot enter into contracts, nor can it become liable for contracts made on its behalf. This leaves promoters in an arguably weak position in demanding subsequently payment for their services. A promoter has an action against any person with whom they have contracted personal liability and not against the company, unless the company subsequently ratifies the transaction. Actions taken by the promoter in setting up the company expose them to personal liability, which persists even if the company ratifies actions done by the promoter post its incorporation. In our scenario, Anna and Conrad would be the promoters and subsequent shareholders, members, and directors of the new company. It is unlikely that on these facts there would be conflicting interests between them and the newly formed company. We have discussed on a number of occasions that English law does not take a too prescriptive approach to controlling the organizational aspects of firms. The idea is that freedom of contract prevails, and that the firms themselves should adopt whatever structures they consider to be most appropriate to their business. However, minimal statutory requirements mean that there are expanded opportunities for abuse from the people tasked with managing the company. What is there to stop the directors of using the company as means of self-enrichment, rather than using it to benefit the shareholders? The key power of the shareholders is the one found in Section 168. They can dismiss the directors at any time by ordinary resolution. However, the law does contain a series of rules to prevent abuses and protect the shareholders. The 2006 Act contains these rules in Chapter 2 of Part 10 under the heading General Duties of the Directors. There has been a lively discussion on whether directors' duties ought to be static, enshrined in statute, or they would be better off left to the courts, so they can evolve alongside business practice. The duties of the directors are owed to the company both in common law and by statute, Section 170. Duties therefore are not owed to individual shareholders or employees. Only those who are able to act on behalf of the company can enforce the duties. The Companies Act lays out in detail the duties of the directors to their company. The most significant duty, and one that will be immediately of relevance to Anna and Conrad upon setting up their company, is the one contained in Section 172, which states that a director of a company must act in the way they consider, in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard, amongst other matters, to the likely consequences of any decision in the long term. The interests of the company's employees. The need to foster the company's business relationships with suppliers, customers, and others. The impact of the company's operations on the community and the environment. The desirability of the company maintaining a reputation for high standards of business conduct. And the need to act fairly as between members of the company. This provision is important because it forms the basis of the statutory acceptance of corporate social responsibility in English law. This is supposed to be a modernized version of shareholder primacy, including a series of other considerations that contribute to the long-term success of a company. This is also known as enlightened shareholder value. The idea behind this formulation is that the interests of the shareholders are unlikely to be advanced if the management of a company conducts its business so that its employees are unhappy, its suppliers and customers would rather avoid it, it is at odds with the community in which it is based, and its ethical and environmental standards are regarded to be unacceptable. Success is defined in commercial terms as there is an assumption that the company is a commercial company. The directors are expected to behave, subjective test, in the way they consider, in good faith, as the most likely to promote the success of the company. However, this is not to suggest that the interests of stakeholders are now at equal level with the interests of shareholders. The directors consider external interests to the extent that this is desirable to do so in order to promote the success of the company for the benefit of its members. The members' interests are still paramount. Not all companies that do business in the UK are incorporated under the Companies Act. A company incorporated outside the UK is called an overseas company. Legislation also deals with overseas companies with the aim of ensuring that there is availability in the UK of the same basic information about a company incorporated abroad which has an established presence in this country. There are therefore specific disclosure requirements for overseas companies having an establishment in the UK. Establishment can be defined in two ways as branch or a place of business. A branch is a place of business through which the company directly conducts some or all of the operations inherent in the business. A branch therefore has the appearance of permanence and is physically equipped to negotiate business with third parties directly. A place of business, on the other hand, requires a degree of permanence or recognizability as being a location of the company's business. However, what gets done can be purely ancillary to the company's business, such as warehousing or data processing. An overseas company which opens an establishment in the UK needs to notify the registrar with information about it and its establishment. Failure to do so is a criminal offence but does not affect the validity of transactions conducted by the company. Generally, in English company law, there tend to be criminal penalties for violations, but the transactions themselves are not voided as this presumably protects market expectations. Having published contact information for a company ensures that one is able to serve documents if they want to bring action against them. Ongoing disclosure requirements contain those matching trading rules and annual reporting. Of course, overseas companies are still regulated according to the rules of their place of incorporation. In this episode, we focused on the process of setting up a new company in the UK. This podcast presented the necessary stages one needs to go through to set up a private limited company and described the documentation required. We guided our inventors Anna and Conrad through the various choices they will need to make when setting up their new company. The episode explained how decisions are made on organizational structure, how to select a name, what type of information disclosure is needed and at which stage, what the steps are when one seeks to incorporate a company and at what cost. We also touched on the rights and obligations of promoters and directors as well as options for overseas companies seeking establishment in the UK. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about investing and participating in small and medium enterprises in the UK, discussing elements of personal and corporate taxation. Without further delay, let us get started on the content of this episode, which focuses on elements of personal and corporate taxation in the UK. We will present how various choices in business organization affect tax liability and take our inventors Anna and Conrad through the tax implications of various organizational choices. Tax liability will be one of the key elements in deciding on organizational structures for carrying out business, as different forms of organization can have divergent outcomes in one's tax exposure. Optimizing business structures for tax purposes is something that will be at the forefront of entrepreneurial thinking as one sets out to create a business in the UK or invest in UK-based enterprises. In the UK, the main provisions of income tax are present in the Income Tax Act of 2007. The basic position is that every individual with business activity, income from work or investment, will pay tax on their total taxable income each year. The income to be considered is what they have received through their activity minus any relevant allowances, deductions and reliefs as determined by HMRC. Remember that in the UK the tax year runs from April to April, it is not the same as the calendar year. Any tax liability will be accessed within this period. The sources of income for Anna and Conrad most likely will comprise of income received through salary, through pursuing their trade or profession, but also income received indirectly through interest on deposits and savings, dividend payments on shares and rental income from properties, real or movable. If one's income is derived solely through employment, HMRC will assess tax liability automatically through the information provided by one's employer and income tax is deducted at source, before one receives their monthly salary. This system is known as PAYE, which stands for Pay as You Earn. In the UK, therefore, employees receive in their bank accounts money they can use directly, and any deductions for tax, national insurance, or pension contributions have already been taken in advance. Additional income not taxed in this fashion will need to be declared either directly to HMRC, so it passes on to the relevant pay code and taxed at source, or through a tax statement at the end of the tax year. Any unpaid income determined through a tax return will be then paid directly to HMRC or added to next year's tax code and withheld at source through pay as explained earlier. Remember that HMRC assesses one's taxable income. Not all income is taxable. For example, pension fund contributions are tax exempt. Therefore, if Anna earns £50,000 per year, but £6,000 of that are paid towards a future pension, then her taxable income will be £44,000. This applies to most private pension schemes, for example workplace pensions, personal and stakeholder pensions, overseas pension schemes that qualify for UK tax relief. Most pension funds in the UK are private and independent of state support. The government of the UK will set income tax rates for each year in the budget. There are several tax rates presented in bands. Those with taxable income below £125,140 benefit from a personal allowance of up to £12,570 on which they do not pay any tax at all. For April 2022 to 2023, for example, a basic rate of tax at 20% is deducted from income between £12,571 and £50,270. A higher rate of 40% is deducted from income between £50,271 and £150,000. Finally, there is an additional rate of 45% for income exceeding £150,000. Note that income tax deductions follow these bands. Anna and Conrad should not worry that once each person's income goes above, say, £55,000, they will be liable to pay 40% tax on the total amount. This is a common misconception. The rationale for the bands is to make the income tax system progressive, taking a higher percentage from people who can afford it the most, as they have higher incomes overall. This can be contrasted with value-added tax, VAT, a regressive form of taxation, which burdens everyone the same way, regardless of their wealth generation in any given year. For your information, the rate of VAT in the UK in 2022 stood at 20% for most goods and services. The taxation of a business is primarily based on the form of business organization the entrepreneur has chosen to utilize. Going back to our earlier podcasts, you will remember that Anna and Conrad had a series of options available to them. They could operate their business in their personal capacity as sole traders, through a partnership, or through an incorporated company. It is only the latter that offers tax treatment differential to the one for individuals, as described above. For sole traders and partners, the tax affairs of their business activity are not distinct from those of their personal ones. Specifically for partnerships, it is worth noting that as a partnership is not a separate legal person, for tax purposes it is treated as a group of individuals, a set of notional sole traders. The main distinction between business taxation for individuals and arrangements under pay is the treatment of business expenses. Only profits attract taxation, and in order to determine what these are, one has to separate income receipts generated from trading activities and deduct expenditure included in the process of preparing and delivering goods and services. Another distinction needs to be made between income generated through trading and capital receipts generated through the sale of fixed assets. There are different rates of tax for income and capital gains. In the UK, there is a different rate of tax on gains from residential property than on sales of other assets, and there is usually no tax when you sell your home. It is the buyer of the property that pays a tax, known as stamp duty. Basic rate taxpayer will pay tax depending on the size of gains, their taxable income, and whether any gain is from residential property or other assets. If this amount is within the basic income tax band, one will be asked to pay 10% on the gains, or 18% on residential property. For people above the basic tax band, the charge is 20%, or 28% on residential property, on any amount above the basic tax rate. It is worth noting that sole traders or partners will pay 10% if the gains qualify for business asset disposal relief. This covers the situation when one sells, or disposes of, all or part of their business. The rules through which trading income is determined and subjected to income tax are contained in the Income Tax, Trading and Other Income Act of 2005. Coming back to expenditure, we need to note that in order for any expenses to be deductible from income receipts, there must not be of a capital nature and they must have been fully undertaken for the purposes of the business. Examples include rent for business premises, salaries paid to employees, utility bills, local taxes, purchasing stock for sale, advertising costs and office equipment. Remember that accurate account keeping, within each tax year, is necessary in order for a business to be able to claim any allowances for expenditure. While these accounts do not have to fully audited, certain key pieces of information, creditors, debtors, work in progress, stock, must feature in them for HMRC to take them into account. If a business makes a trading loss, it will incur no income tax liability for the relevant tax year. Additionally, tax relief will be available in the form of a set-off against same and preceding year income. It is also possible for loss to be set against profits from the same trade in future years, to the extent that it has not been compensated already. There are also specific provisions to make this easier for businesses that are just starting out. For more information, see Section 72 of the Income Tax Act 2007. We will focus from now on the tax affairs of corporations, which will be most relevant to any business venture started or invested in by our pair of inventors Anna and Conrad. We will start by considering the tax liabilities of the corporate itself, before moving on to consider the position of those who invest in companies, as shareholders or through debt instruments. The main pieces of legislation as regards corporate taxation are the Corporation Tax Act of 2009 and the Corporation Tax Act of 2010. A company's taxable total profits subject to corporation tax are calculated by adding the amount chargeable to corporation tax on income after any applicable reliefs plus any amount in respect of chargeable gain after any applicable reliefs. This generates the total profits of the company. Any reliefs against income of chargeable gains are considered before calculation of the total profits, therefore reducing the amount. An example of what counts as a relief would be charitable donations. Then one deducts any amounts which CAB-NE relieved against the total profits to find the taxable total profits. You should remember that remuneration or rewards paid to a company's employees entitle it to a pre-tax deduction and reduce its taxable profits. This will include the payment of salaries, wages, pension contributions or lump sum payments in compensation for dismissal. Employee benefits that can also be included could amount to company cars, meals, expense allowances and so on. Employer national insurance contributions are also deducted from profits in the assessment of tax liability. The main type of profit that a company, such as the one envisaged by Anna and Conrad will come from trading. How such profits are calculated depends on prevailing accounting practice, and legislation offers specific rules on how to calculate trade profits. The important thing is what counts as a deductible expense, usually expenses incurred wholly and exclusively for the purposes of the trade and losses that arise out of the trade. Companies will also be charged corporation tax on other forms of income, such as income from property, interest on loans or financial assets and investments. Unlike individuals, corporations do not benefit from a personal allowance when calculating their tax exposure in any given year. The same goes for capital gains, whereby companies are not entitled to an annual exemption and do not benefit from most reliefs available to individuals. Companies will, however, benefit from an indexation allowance, not available to individuals, which removes any inflationary gains from tax charges. This brings us to the issue of assets that appreciate in value in general. If a disposal of an asset leads to an increase in company wealth, which in return causes shares to appreciate, the company may be concerned about double taxing of the same gains. Mechanisms such as the indexation allowance are introduced to deal with these types of issues. At Spring Budget 2021, the government announced an increase in the corporation tax main rate from 19% to 25% for companies with profits over £250,000, together with the introduction of a small profits rate of 19% with effect from the 1st of April 2023. The small profits rate will apply to companies with profits of not more than £50,000, with marginal relief available for profits up to £250,000. Corporation tax is normally payable 9 months after the end of the accounting period. However, larger companies, with profits exceeding £1.5 million, have to pay their taxes in installments on a tighter schedule. Where this happens, the company needs to estimate its tax liability and adjust payments accordingly, and any over or underpayments are subject to interest at the official rate. Trade losses are relieved in ways similar to those for unincorporated businesses that we discussed earlier. A company may set off a loss made during a tax year against future tax liabilities. This can happen for trade losses or capital losses. There are also some provisions for some relief for losses allocated within group structures between parent and subsidiary companies. Anna and Conrad will be able to benefit from participation in a company either through their status as employees, or through their status as investors through shareholding, meaning via the payment of dividends on the shares. What should be understood is that choosing to incorporate means that there will be a fundamental and legally enforced distinction between company and personal finances. Our two entrepreneurs therefore will not be in a position to extract wealth from their business, unless this is formalized, with the two methods mentioned earlier being the most common ways to participate in corporate wealth creation. The tax implication of these facts is that apart from the tax affairs and liabilities of the company, Anna and Conrad will incur personal liability for any earnings they extract from the business. Depending on the personal position, there may be some benefits in one method, for example capital gains, over another, for example wages, but there is no automatic tax benefit that applies without context. Therefore, the commonly held view that engaging in business through a corporate brings immediate tax benefits tends to be erroneous. See the discussion on personal liability at the beginning of the lecture. Employee benefits, beyond the payment of salaries and bonuses, are also subject to tax at the personal level. For example, if Anna Con Limited rents a property for £8,000 per year to provide accommodation to Anna and Conrad, for which they pay £4,000 a year, they will receive a taxable benefit of £4,000, which they will need to declare in their self-assessment tax statements. Also, any money offered for expenses that have not actually been spent for the purposes of employment will become taxable. For example, if Anna receives £100 per month for expenses, but only spends £80, the remaining £20 will be taxable. Note that a company is not allowed to avoid pay management costs and the payment of employers' national insurance and pension contributions by offering work to its personnel as contracts and paying them on a contract basis. This is covered by the rules. This are quite controversial, on IR 35. HMRC will deem attempts to circumvent an employer-employee relationship as violations and the company will become liable to contributions in the normal way. The consequence for personnel of tax-efficient arrangements is that employment law rights may be affected regardless, so Anna and Conrad should consider carefully not only the tax implications of various arrangements, but also their personal interests and protections as employees as opposed to contractors. If Anna and Conrad receive benefits from their participation in the company in the form of dividends on shares, they will be liable to income tax. These payments include any dividend paid by the company, distribution of additional shares, in some cases, and any interest paid on securities, financial assets, where the interest paid is dependent on the profits of the company. For the avoidance of doubt, the payment of dividends does not reduce the company's liability towards corporation tax. Individuals in receipt of dividend payments are subject to different tax rates than the ones applicable to the rest of their income. As of April 2022, the dividend ordinary rate, for base rate taxpayers, is set at 8.75%. The dividend upper rate, for income up to £150,000, is set at 33.75% and the dividend additional rate, for income above £150,000, is set at 39.35%. Any individual who has dividend income can benefit from the dividend allowance which has been set at £2,000. Dividends within the allowance are not charged any tax. If Anna and Conrad live in France, but engage in business in the UK, they will still need to consider the tax implications of their UK-based activities. Non-UK tax residents are still liable to pay income tax on income derived from activity in the UK. They may also be liable to capital gains tax for the sale of assets, including, but not limited to residential properties. Whether one has tax residency in the UK will depend on the outcome of a statutory residence test, which contains a series of questions about each person's links with the UK and the time they spend in the country, either for work or otherwise, that help determine tax residency. Even Anna and Conrad are determined to be not resident in the UK for tax. They may still have to fill in a tax return if they are directors of their company and receive payment for their duties, if they derive income from real estate or if they sell property of other assets liable to capital gains tax. In order to file a tax statement, one needs to contact HMRC before October each year to declare income received during the prior tax year. Failing to declare taxable income to HMRC attracts penalties and fines that increase the longer the delay is. What Anna and Conrad will be most concerned about is the possibility that they may be taxed twice for the same income in the UK and back home in France. Choosing where to be taxed to take advantage of any lower rates is not really the issue in this context, as we are considering actual activity taking place in the UK, as opposed to a scheme for tax optimization. It is important to note, however, that one can only benefit from tax allowances and exemptions only in their country of origin. Anna and Conrad could not claim both exemption from tax for their initial income in France and claim their personal allowance in the UK at the same time. They will need to make a choice, and if they can genuinely choose where to locate for tax purposes, whether one regime is more beneficial than the other will certainly affect the decision. Generally, if someone lives in one country and are a member of the management board of a company in another, the country where the company is located may tax fees and income related to this role. Most countries will treat as part of taxable items any benefits in kind, for instance stock options or company car, that one receives as a board member. If, alongside a role as a board member, one works for the same company as an advisor, a consultant or an ordinary employee, income from these functions will most likely be subject to the same tax treatment as that applied to cross-border commuters. A cross-border commuter is someone who lives in one country and works in another. The taxation rules applicable to income will depend on national laws and double tax agreements between these two countries, and rules can differ considerably from those that determine which country is in charge of social security issues. Depending on the applicable double tax agreement, one may have to pay taxes in the country of work as well as in their country of residence. If one is an employee, the country where they work will, in most cases, tax the income earned on its territory. If one is self-employed and registered as such in the country where they live but provide services across the border, they will generally have to pay income tax in the country where they provide services if they set up a fixed base or permanent establishment, such as an office or a shop, there. If one lives in one EU country but earns all or almost all of their income in another and pay tax there, the country where the income is earned should treat them as it would treat a resident. That is, it should offer the same tax reliefs and tax exemptions and any other tax benefits available to residents, such as personal allowances, or the possibility to complete a joint tax return with a spouse. Brexit has complicated the position of foreigners engaged in business activity in the UK both for immigration purposes, right to work, and in terms of tax exposure. The tax treatment of interest, royalty and dividend payments from the EU to the UK post-Brexit is dependent upon the domestic law of the source country and the relevant tax treaty between that country and the UK. Although the UK has an extensive treaty network, some treaties including those with Italy, Portugal and Germany offer a less favourable outcome than has been the case under the EU directives. Luckily, France and the UK have a treaty for the avoidance of double taxation and for cooperation in issues of tax. The treaty specifies that the industrial or commercial profits of a United Kingdom enterprise shall not be subject to French tax unless the enterprise carries on a trade or business in France through a permanent establishment situated therein. If it carries on a trade or business as aforesaid, tax may be imposed on those profits by France, but only on so much of them as is attributable to that permanent establishment. An individual who is a resident of the United Kingdom shall be exempt from French tax on profits or remuneration in respect of personal, including professional, services performed within France in any year of assessment if they are present within France for a period or periods not exceeding in the aggregate 183 days during that year, and the services are performed for or on behalf of a resident of the United Kingdom, and the profits or remuneration are subject to United Kingdom tax. In this episode, we focused on elements of personal and corporate taxation in the UK. We presented how various choices in business organisation affect tax liability and take our inventors Anna and Conrad through the tax implications of various organisational choices. We started off with an overview of UK tax for individuals, reviewed the tax implications of various types of business organisations and spent some time concentrating on corporate tax affairs. We then considered the tax liabilities of company personnel and discussed the position of foreign entities operating in the UK in terms of tax. We finished with a reflection on tax cooperation between France and the UK and provisions for the avoidance of double taxation. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about issues relevant to those wishing to bring their companies to a stock market. We discuss the fundamentals of investing in stock markets, present the key elements of the regulatory environment and its rationale, and explain what is involved in floating in a stock market. Without further delay, let us get started on the content of this episode, which focuses on issues relevant to those wishing to bring their companies to a stock market. We discuss the fundamentals of investing in stock markets, present the key elements of the regulatory environment and its rationale, and explain what is involved in floating in a stock market. Securities markets are important components of modern economies, and theory suggests that they help to bring about the most efficient use of capital resources. This depends on there being a good regulatory system in place, which ensures that the markets operate in a clean and transparent manner so that investors have confidence in them. This in turn depends largely on having rules that compel full and timely disclosure of all material information about the companies whose securities are traded on the markets. By securities we mean negotiable financial instruments that hold monetary value. Capital markets are markets where people, companies, and governments with more funds that they have an immediate need for, because they save some of their income, transfer them to people, companies or governments who have a shortage of funds, because they want to spend more than their income. Capital markets promote economic efficiency by channeling money from those who do not have an immediate productive use for it to those who do. The stock market and bond market are examples of capital markets. The principal actors in capital markets are banks, non-bank financial institutions, corporations and governmental agencies. A company may well be able to raise the funds it needs from the small group consisting of its existing shareholders, but participation in markets offers several advantages. They help buyers and sellers to determine the appropriate price of the financial asset being traded. They offer a mechanism for buying and selling financial assets. And they help investors to locate counterparties, thus saving time and cost. One could say that the purpose of markets is to increase liquidity, in other words, the availability of money. What does all this mean for our inventors Anna and Conrad, and should they seek to float their company on the London Stock Exchange? There are two distinct, yet combined operations which may take place when a large company seeks to raise finance from the public. On one level, it needs to make its intentions known to those willing to purchase shares. The most heavily regulated methods of attracting investors are the public offers of securities because the general public needs to be protected. This logic extends as well to more sophisticated counterparties, who also benefit from full and timely disclosure of information. On a second level, the more liquid a market, the greater the chances of attracting investment. This is why companies choose to list on a stock exchange, to ensure both access to potential investors and to give investors the peace of mind that they can with little difficulty realize their investments. You can contrast the ease of doing business in a stock market, and the transparency that comes with it, with the potentially lucrative, but secretive world of cryptocurrencies and the associated lack of liquidity that characterizes those markets. What markets are available to Anna and Conrad in the UK? The LSE, London Stock Exchange, is not a single market, as it comprises of two distinct entities. The main market is for well-established companies and the alternative investment market, AIM, is for less well-established companies. AIM is the London Stock Exchange's international market for smaller growing companies. A wide range of businesses including early-stage, venture capital-backed as well as more established companies join AIM seeking access to growth capital. There is no monopoly on exchanges, and other markets can exist so long as they satisfy regulatory requirements. Also, there is no obligation for UK firms to trade on a British exchange. A company can have a primary listing in London, and a secondary abroad, and foreign companies can either have a primary or secondary listing here. This creates competition between exchanges, and it is one of the reasons why policymakers are worried about companies leaving, and London losing its competitive edge as a centre of business every time someone proposes some new layer of regulation. We will focus in our lectures on the markets offered by the London Stock Exchange. The Financial Conduct Authority, FCA, regulates exchanges in the UK. After Brexit, the UK regulatory environment is domestically based, but it is likely to mirror closely the EU one for some time to come. The EU requirements for a regulated market are in the relevant directives and regulations MiFID II and MiFIR. You will have probably heard of the FTSE in relation to the London Stock Exchange. The FTSE is not the stock market itself, but an index of specific shares listed on this stock market. There are several Financial Times Stock Exchange, or FTSE, indexes. The most quoted is the FTSE 100, originally developed by the Financial Times newspaper and which includes the 100 largest companies by market value on the London Stock Exchange. There are several other FTSE indexes that cover smaller companies or broader aggregations of companies. The FTSE indexes are indicators of stock prices in the UK, used in a similar fashion to the Dow Jones, S&P and Nasdaq indexes in the US. When a company decides to raise funds from the public, whether by issuing new shares or debt securities, the relevant financial asset will be created and distributed for the first time. In other words, it is brought into existence and issued to the investor in exchange for cash, which is paid to the issuing company. This process occurs on what is known as the primary market. After an investor has acquired a financial asset, he may wish to sell it to another investor who wants to buy it. The organized markets where people trade in financial assets that have already been issued are the secondary markets. On these markets, money changes hands between the buying and selling investors, but the company that issued the financial asset is not a party to the transaction and does not receive any further funds. Therefore, if Anna and Conrad were to launch a public limited company, let's call it Anna Con plc, they would engage in a process whereby the public purchase shares from them. The money is paid to the company, but from that point onwards, the public can sell and buy from each other, without requiring permission from the company, or returning any money to the company again. This is the main difference between a private and a public company, as in the former, the permission, or involvement, of the company is required for all share transactions. Regulation around securities and in particular traded shares aims to achieve the creation of a type of consumer law that protects the buyers of shares from being taken advantage of, in the same way that consumer law for the sale of goods ensures minimum standards of safety and quality are respected. Regulation also aims to achieve allocative efficiency, by helping the market reach the most efficient outcomes when these cannot be reached by pure market processes. This is done primarily by facilitating flows of information between firms and investors. There are two methods whereby regulatory intervention can have efficient outcomes. One is by emulating standard consumer law and safeguarding standards. The second is by mandating disclosure and then empowering the consumer to make the correct choices according to their wishes. The implementation and enforcement of the regulatory system is entrusted to a public body. For example, the Securities and Exchange Commission, SEC, in the US, and the Financial Conduct Authority, FCA, in the UK. Standards are fairly common globally and include, at a minimum, an obligation on the issuer of securities to disclose all relevant information so that investors can make an informed decision, rules to ensure that an issuer continues to make relevant information available, an obligation on the issuer to treat all investors, and shareholders in particular, in a fair manner, an obligation on financial intermediaries, to be organized and to operate in a way which safeguards the integrity of the market and protects investors, rules designed to deter manipulation and other unfair trading practices. It becomes evident from the above that information disclosure is of the utmost importance in stock market operations. There are several additional stock exchange-related obligations in corporate law in the UK that can be summarized as follows. An obligation to observe, on a comply or explain basis, the provisions of the UK Corporate Governance Code, dealing with the composition of the board and the role of independent non-executive directors, the rules on related party transactions, especially the requirement for shareholder approval in certain transactions, the rules on significant transactions, with or without an element of self-dealing. It is important to note here that the regulatory framework covers securities beyond shares. Securities issued by companies essentially carry a promise by the issuer to pay an amount of money in the future and can take the form of debt securities. The amount of money paid is generally fixed, and equity securities, meaning shares, whose income generation depends on the future income of the company. Whether a company is able to meet its promise to return a profit to its investors will depend on a variety of factors, such as market conditions, the competence of managers, the dedication of employees, the prospects of the particular sector, the suitability and proper execution of the business plan, and so on. The law does not guarantee performance of obligations, but ensures that sufficient information is shared to allow people to balance the risks of doing business. Companies raising money from the public obviously cannot provide a guarantee of their future performance and financial health. But, equally obviously, the managers of the company, and, if it is a private company, its shareholders, possess much better information about these matters than do prospective investors. The objective of securities regulation is therefore to ensure that all relevant information is made available to investors so that they can make an informed judgment about the securities that they are being invited to invest in. Modern regulatory regimes therefore require that investors should be provided with full, timely and accurate disclosure of current and reliable information which is material in enabling people to make investment decisions. This principle is directly related to the objectives of investor protection that we identified earlier as the promotion of fair, efficient and transparent markets. The law has strict penalties for failing to meet requirements and penalizes fraud, misrepresentation and various types of market abuse. What types of information should one expect to receive from a company in general and specifically one interested in joining a stock exchange? The directors of a company are obligated to produce annual accounts relating to the financial position of the company and to accompany those accounts with a report on the company's activities, including their own stewardship of the company. These documents are normally presented to the shareholders at the annual general meeting, AGM. Note that only public companies are now obligated to have an AGM. What these statements consist of is largely the business of accountants, and the accounting profession has played a major role in developing the standards which determine how the raw financial data is analyzed and presented in the accounts. Because these reports are used not only by members and creditors, but also by the wider investing community, disclosure rules have become part of securities and capital markets law. Obviously, the bigger the company, the higher the need to have publicly available information. Therefore, small companies are exempt by some of the disclosure requirements found in the Companies Act. For example, the Act provides in S.386 that the company shall keep records sufficient to show and explain the company's transactions, to disclose with reasonable accuracy at any time its financial position. This is done so that the company complies with Reg 1606/2002, EC on the application of International Accounting Standards, IAS regulation. As to the form of the statements, the British approach has been to leave things to the accountants, while the continental one to mandate forms. As a result of IAS and the company law directives, a mix now is in place in the UK. The traditional British approach can be summarised as requiring accounts to give a true and fair view of the assets, liabilities and financial position, profit and loss, of the company. A director's annual report is a statement to accompany both individual and group accounts of companies and is a statutory requirement in the UK supported by criminal sanction. The directors of quoted companies are also required to produce a remuneration report and publish additional information which includes forward-looking, soft data that is different from the numbers-based accounts. The report requires a list of those who are directors of the company, or have been in the course of the year, and an account of the company's principal activities in the course of the year. It must also recommend the amount of dividend to be paid to shareholders. Inaccuracies in the reports can lead to liability of the directors to the company and of the company to third parties including investors in the case of fraud. The directors' general duties cover the accuracy of the reports, but there is a statutory impression as well in the companies covering liability for false or misleading statements in reports. As a consequence of this, a director of a company is liable to compensate the company for any loss suffered by it as a result of any untrue or misleading statement in a report, or the omission from a report to which this section applies of anything required to be included in it. A director is liable only if they knew the statement to be untrue or misleading or was reckless as to whether it was untrue or misleading, or knew the omission to be dishonest concealment of a material fact. It is important to note, however, that investors, excluding existing shareholders, cannot impose liability on the company in respect of unsuccessful investment decisions which are based on inaccurate information in the directors' reports. But this protection does not extend to fraud. The final document that accompanies the annual accounts is the auditor's report, for those companies required to have their accounts audited. Note that small companies benefit from an exemption. The audit is addressed to the shareholders and states whether in the auditor's opinion the annual accounts have been properly prepared in accordance with the law and whether they give a true and fair view of the state of the company. The report also states whether the director's report is consistent with the data in the annual accounts and whether it was properly prepared. The auditor's report also comments on whether adequate records have been kept by the company and whether the individual accounts are in agreement with the accounting records. The annual accounts and reports are filed with the registrar, as are the company's articles, a list of the company's directors, the address of its registered office, the amount at issue of its share capital and details of charges on its property. Auditors are meant to be independent of the company, even though they get paid by the company. There are severe consequences to prevent lax audits, and the law contains mechanisms to ensure that auditors do their jobs properly. Auditors cannot audit a company with which they are connected, conflict of interest. Shareholders also have increased supervisory roles, as to the non-executive directors who are responsible for appointing the auditors. Auditors are liable in a civil court to those who rely on negligent accounts and suffer losses as a result, and there is criminal liability for false statements in audit reports. In a way, therefore, while the company is not liable for the content of statements, apart from cases of fraud, the auditors are. To summarize, the above information should not lead you to the conclusion that anyone who looks at the audited accounts and buys shares in a failing company has a claim. Only when a special relationship brings a duty of care into being between the company's directors and the person suffering loss will the company be called upon to compensate. We mentioned already that a public company and a listed company are two different things. Legislation applies differently to public companies that are also listed, and of course stock exchange rules only apply to publicly listed companies. For Anna and Conrad to enter a stock exchange, they will first need to re-register their private limited company to a public limited company. This will necessitate an increase in the minimum capital of the company to £50,000 as well as a re-registration process and the additional supply of information as required by legislation. A public limited company wishing to have its shares traded in the LSE will need to have them admitted to the official list of securities, maintained by the FCA in its capacity as UK Listing Authority or UKLA as it used to be called. The FCA regulates entry to the stock market in the interests of protecting shareholders through the release of information about the company. However, some of its rules also govern the company's conduct after listing. The rules, for instance, contain provisions on related party transactions and significant transactions that supplement provisions in the Companies Act. Also, these rules provide the legal basis for the UK Corporate Governance Code. Contrary to the freedom of choice regarding the Articles of Association and the organisation structures of a private limited company we have discussed already, Anna and Conrad will find out that on an initial public offer of the shares of a public company on a stock market, there is not a great deal of freedom for a company. A large issue of shares necessitates that the company will need to offer the shares for sale and at the same time be listed on the exchange. Smaller amounts may be raised by what is called a placing, shares not sold to anyone, but placed with specific investors, for instance banks. A large public offer of shares is a complex endeavour that will need to be facilitated by a specialist investment bank. When a company offers its securities on the primary market, it will employ the services of an investment banker. The role of the investment banks is to advise the company on the terms and timing of the proposed public offering, buy the securities from the company and/or distributing the securities to the public. The second of these functions, purchasing the shares, is generally referred to as underwriting and is not a necessary part of the arrangement. Where it is, the bank may either buy the whole issue from the company and then try to resell the securities to the public in the secondary market, or it may first try to distribute the securities to the public and agree to take up any that are not taken up by the public. Underwriting involves obvious risks for the bank, since the bank will effectively be agreeing to invest its own funds in the company rather than simply providing professional advice and services. Investment banks naturally charge a commission commensurate to the level of work involved and the amount of risk they take on. What sort of offering documents does a company need to supply during the process of being admitted to the London Stock Exchange? In an initial public offer, or IPO, the offer must be accompanied by an offering document, or document, prospectus, which contains extensive information about a wide range of matters. Broadly speaking, any material information that might affect the price or value of the securities being offered must be disclosed. The preparation, publication and distribution of this document, before potential investors actually part with their money, are the primary focus of the regulatory process in the primary market. The regulator will often have general oversight of this process, without itself vouching for the accuracy of the information disclosed, and sanctions will be provided for the directors of the issuing company, and others involved, if they fail to exercise due diligence in the gathering and presentation of information. In the UK, the FCA will be responsible for regulating conduct in retail and wholesale markets, including both exchange-operated markets and over-the-counter, OTC, dealing. It is tasked with supervising the trading infrastructure that supports those markets and for the prudential regulation of firms not regulated by the Prudential Regulation Authority, PRA. Listed securities are those that have been admitted to the official list, maintained by the FCA. The purpose of this list is to demonstrate official approval for the relevant securities to be traded on the main board of the London Stock Exchange. Because the regulator requires compliance with certain requirements before accepting securities onto the official list, the list serves as an indicator that certain standards have been met and that various continuing standards of behavior and disclosure have also been imposed. Companies want to have their securities admitted to the official list because this gives them access to the main board of the London Stock Exchange, which in turn provides liquidity for investors in their securities as well as giving those investors the confidence that comes with having the securities traded on a carefully regulated market. These advantages come at a price, however, and that is the cost of complying with onerous listing requirements. Securities that are not admitted to the official list are referred to as unlisted. There is a further distinction between those securities that are being publicly offered versus those securities being publicly traded. Offering refers to the process by which securities are marketed to investors, i.e., on the primary market, while trading refers to the means by which investors subsequently buy and sell securities among themselves, i.e., on the secondary market. A company seeking listing will have three options: to issue securities that are offered to the public that are then traded on a market to which the public has access, so as to facilitate sales and purchases among investors; securities that are offered to the public without also being publicly traded, though this obviously entails a loss of liquidity for the investor; and securities that can become publicly traded without having been offered to the public. To remind ourselves of an earlier distinction, a public company is one that offers its shares to the public. It's only a public listed company that does this via a recognized stock exchange. If a company does seek to float in a stock market, what types of documentation are they expected to produce? There are several different ways in which securities can be brought to listing. For a company making an initial public offering, the main ones are: 1. An offer for sale, whereby a sponsoring issuer, an investment bank, has agreed with the company to subscribe for the securities to be issued and then offers these for sale to the public. 2. An offer for subscription, whereby the company itself directly offers the securities to the public for subscription. The document by which securities are offered is known either as a prospectus or as listing particulars. A prospectus is required for securities that are to be offered to the public for the first time before being listed, while listing particulars are required in other cases. In practice, this is essentially a matter of terminology only, since there is little difference between the two types of document in terms of their content. Legislation, such as the Financial Services and Markets Act of 2000 and the Financial Services Act of 2021, contains what are known as fundamental disclosure rules that a company must comply with in order to list its shares on an exchange. The fundamental rule is that prospectus, listing particulars, must contain all such information as investors and their professional advisors would reasonably require, and reasonably expect to find there, for the purpose of making an informed assessment of a. The assets and liabilities, financial position, profits and losses, and prospects of the issuer of the securities, and b. The rights attaching to the securities. Required information covers the following general areas: identification of those responsible for the prospectus, listing particulars, including the directors, auditors, bankers, and legal advisors; the shares, or debt securities, being offered, including the rights attached to them and whether any price stabilization activities will be entered into; the company and its capital, identifying anyone who could exercise control over the company and anyone holding 3% or more of its capital, and also giving details of material contracts; information about the group of which the company is a member, including information about intellectual property rights and commercial or financial contracts which are of fundamental importance, significant legal disputes, and the principal future investments which have already been committed; the company's financial statements, with auditor's report, for the last 3 years, including cash flow statements and information about any significant change in the financial or trading position of the group since the most recent financial statements, and a statement about working capital; information about the directors and other senior managers, including relevant management expertise, outside activities, any public criticism by a regulatory authority, remuneration, interests in the company's shares and interests in unusual or significant contracts; general information about recent trends in the group's business and its prospects for the current year, including an auditor's report on any profit forecast. Every listing goes through a process of vetting and registration. Listing particulars must be approved by the regulator before they are published or circulated. There are several documents which have to be submitted to the FCA with the draft prospectus, listing particulars, such as a letter about the company's working capital and a letter signed by all the directors. The vetting process will normally take at least 10 working days, but for new applicants or in complex cases, double this may be required. In giving its approval to listing particulars, the regulator is not commenting on the merits or otherwise of the proposed investment. They are just making sure that the listing particulars contain all the information that is required by legislation and the listing rules. In the process, the regulator may comment on things that are not clear or are contradictory, but it is emphatically the responsibility of the directors, not the regulator, to ensure that the listing particulars are complete, accurate, and not misleading. The FCA is exempt from liability for anything that it does in performing its functions. After approval, listing particulars must be filed at Companies House, where they are available for public inspection. The listing rules also require that the prospectus, listing particulars are published at the document viewing facility at the FCA and are made available free of charge to members of the public. A formal notice must also be inserted in a national newspaper containing basic details of the offer and stating how to obtain a copy of the listing particulars. After listing particulars have been issued, an error in what is stated may be discovered, or something new may happen which makes a statement in the prospectus, listing particulars no longer correct or which needs an additional disclosure. If this is significant, the company must prepare supplementary prospectus, listing particulars to correct or update the original listing particulars. The supplementary prospectus, listing particulars are subject to the same approval and publication requirements as the original listing particulars. The need for securities markets to be open and honest is so important that misstatements made in connection with listing particulars are considered very serious. They can give rise to liability to compensate another party who has suffered loss, administrative fines imposed by the FCA, and criminal liability. In terms of compensation, legislation provides a statutory remedy to someone who has acquired the relevant securities and has suffered loss as a result of a statement which is untrue or misleading or the omission of information. This right to compensation is not limited to the investor who first buys the securities but extends to subsequent purchases in the secondary market. This right to compensation covers three different situations: where a statement made is not correct, an omission to state something which should have been stated, and/or a statement, or more, which, on their face, are correct but which are misleading have been made. Liability to pay compensation is imposed on anyone who was responsible for the listing particulars, namely the company itself, each of the directors, including anyone named in the listing particulars as having agreed to become a director, anyone stated in the listing particulars as accepting responsibility, experts, such as auditors or valuers, who are responsible for particular parts of the listing particulars, and whose liability is accordingly limited to misstatements in the relevant parts. In terms of criminal liability, misstatements in prospectuses, listing particulars can also result in this type of liability, leading to a large fine and/or a prison term for those held responsible. Liability can arise when someone makes a statement, including a promise or forecast, which is materially false or misleading, whether knowingly or recklessly, meaning, not caring whether it is true or false, or dishonestly conceals a material fact. In this episode, we focused on issues relevant to those wishing to bring their companies to a stock market. We discussed the fundamentals of investing in stock markets, presented the key elements of the regulatory environment and its rationale, and explained what is involved in floating in a stock market. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about the nature of shares and their functions in English law. We present the main avenues through which shareholders participate in the company's success, dividends, and discuss the rules determining how a company can handle its capital. We then look at the main aspects of minority shareholder protection. Without further delay, let us get started on the content of this episode, which focuses on the nature of shares and their functions in English law. We present the main avenues through which shareholders participate in the company's success, meaning dividends, and discuss the rules determining how a company can handle its capital. We then look at the main aspects of minority shareholder protection. In order to understand the rights of shareholders in companies, one needs to have some appreciation of the nature and functions of shares. The first thing to note is that there are different types of shares that a company can issue, with diverse rights and attributes. A key lever in understanding the functions of shares is to remind ourselves that shares are property rights. As such, when asked to make decisions at the company's general meeting, members do not have to vote their shares with the interests of the company in mind. They can do as they wish with the property, which translates as, they can vote for their personal interests even if these are at odds with the company's interests. Shares can belong to two broad categories, ordinary and special. Ordinary shares are those without any particular attributes to distinguish them from the rest. Ordinary shares are a very flexible form of finance for a company because they entitle shareholders to no particular level of return by way of dividend, while shareholders cannot withdraw their contribution without the company's consent at issue, redeemable shares, or via an offer to repurchase on a later date. Special shares will be a subgroup of shares that has something different from the rest, not necessarily better or necessarily worse, just different. Examples include priority in the payments of dividends, something better, and reduced voting rights, something worse. Some controversy exists on whether shares ought to be treated as property rights, or whether they should be perceived to be investments, and as such primarily bundles of contractual rights. The position in English law veers towards maintaining the share's status as proprietary rights. One of the consequences of limited liability is that the law needs to put in place safeguards to ensure that the company operates with an appropriate level of assets, so as to increase the chances that it will be able to meet the claims of its creditors. An important component of this is the idea of the company's capital. This is the value of what the company received from investors in exchange for its shares. The value that the company receives may represent less, however, than the total value of its assets, as the company can raise money from sources other than the shareholders, e.g. by borrowing from a bank. Even if it has not yet started trading, if it has started trading, the company's accounts will contain any profits over and above loans and share value. Value beyond that contained in the shares is not part of the company's capital. The reason for this is that all assets are transient, and the shares are the core of the value that exists to satisfy creditors if things go wrong. Do people really buy shares at £1 or 10p or 1p at issue? It certainly happens, but one needs to distinguish between the nominal value of the share, face value, and the price at which they are actually sold, share premium. It often happens that a share with a nominal value of £1 will sell at a much higher price. The aim of setting a nominal value is to ensure that a minimum amount is paid for the shares. Companies are prohibited from offering shares at a discount from their face value. This is why face values are set at very low levels. If they are set at higher levels, the prohibition from offering them at a discount may deny the company the opportunity to raise funds when it most needs them, at times of crisis. The amount in excess of the nominal value that shareholders pay to obtain their stock is called share premium. We saw earlier that company law should have some mechanisms to preserve value in the company to protect creditors. This comes in the form of capital maintenance rules. But should these rules be based on the nominal value of the shares, or should they also seek to maintain the premium value paid? The essence of capital maintenance rules is that they restrict the freedom of the company to return assets to the shareholders by dividend payments or buybacks, as long as the company's net value is less than its legal capital. By legal capital, we mean the portion of the company's assets that cannot be distributed. The net value of the company is the amount you are left with if you deduct total liabilities from the total assets of the company. Despite the importance placed on the value of the shares as the company's capital, however, English law does not heavily regulate minimum capital. Only public companies need to have that minimum, currently set at £50,000. This requirement came from the Second Company Law Directive, 77/91 EEC, and remains in place post-Brexit. Obtaining the minimum capital is a condition for getting the trading certificate for a public company, therefore it is a very significant requirement. If a company has started trading without the certificate, it is liable to a fine, as is any of its officers in default. Third parties, however, are protected, in the sense that any transactions entered into by the company are valid, but if the company fails to comply with its obligations, the directors are jointly and severally liable to indemnify any losses suffered by the third party. When a company is formed, a company limited by shares, the application for registration must contain a statement of capital and initial shareholdings, the total number of shares to be taken on formation by the subscribers to the Memorandum of Association, their nominal value, the particulars of the rights attached to the shares, the number of shares taken by each subscriber, and the amount immediately paid up for the shares. When more substantial numbers of shares are issued subsequently, information needs to be given to the registrar, return of allotments, and data needs to be provided about those who got the shares, rights and obligations attached to these shares, classes of shares. All this is public information. Remember, however, that this is only a disclosure obligation, not a control as to what the company should actually do. All this is very well, but there is a problem. £50,000 is not likely to offer any substantial security to the creditors of a company. It has been suggested that it would be better if the minimum capital rules reflected the risks related to the business which the company undertakes. Also, the fact that a company has this capital when it begins trading does not mean that it will still be there afterwards. A company that will invest its capital or use it to pay salaries may quickly see it dissipate, therefore even shortly after it starts business, any minimum may not offer much of a cushion for creditors. Obviously, the capital maintenance rules will be more restrictive if they take as the minimal value one that includes nominal value plus share premium. The current law applies the capital maintenance principle to the full value received for the shares with two exceptions. S.610, bonus shares given to existing shareholders for no additional consideration are not counted as part of the firm's capital, and costs incurred in issuing the shares are deducted. What are the rules for company shares at the point of registration? The rules differ quite substantially for private and public companies, as we already discussed. For private companies, it is not necessary that the consideration for the purchase of the shares is fully paid up. Thus, there is a distinction between paid-up capital and the amount of capital that the company is entitled to call upon according to the terms of the share issue, allotment. Payment for shares by way of commissions, brokerage, or any service by a person in consideration is not allowed. However, payment can be made in kind, not in cash, by the provision of goods or property. For public companies, shares must be paid up, in cash or in kind, at least as to 1/4 of the nominal value and the whole of any premium due. If this has not happened, then the allotee has to pay interest charges. It is, however, common for companies to require full payment upon allotment. Any payment in kind in the case of public companies must be preceded by an independent valuation. In conclusion, therefore, the company's legal capital consists of the value of the shares, nominal value and share premium, and it does not fluctuate to reflect changes in the company's position. It is a static amount meant to provide a degree of security to creditors of the company. Any funds that the company has over and above its legal capital and its liabilities are called a reserve, and the company can use it to invest, expand the business, or it can distribute it to the shareholders as profits. What is a distribution? The most common form is the yearly or twice-yearly payment of a dividend by a company to its shareholders, usually in cash, but sometimes with additional shares. The rules discussed earlier set some rough limits on the ability of the company to distribute its profits to its shareholders. We have seen that the company cannot distribute value if its net balance is negative, and it cannot distribute profits if that means that its net value will fall below its legal capital requirement. So long as the company respects that basic framework, it is free to deal with its excess funds in whichever way it wishes, reinvest or give it back to shareholders. Such payments can be very significant. One of the best performers of 2021 has been the mining company Rio Tinto. Based in London, Rio Tinto mines and processes materials ranging from aluminium to copper and diamonds. Its shares yield a lucrative 9.5%, which is roughly the same as the performance of the FTSE in the same year, with a 9.7% rise. While individual shares can fluctuate, however, dividends, for those companies that are consistent in their payouts, may offer a better return than selling the shares on. In any event, both dividend payouts and profits from transactions on rising shares far exceed what an investor would get from just holding savings as cash. The reason for such handsome payouts is that the company is owned by the shareholders, and this is how they recoup their investment. We are used to consider shares in a purely transactional manner, buy low, sell high. However, a lot of shareholders keep shares to benefit from the income generated via dividends and distributions. The internal procedure for authorizing such payments will be detailed in the Articles of Association. The model articles require both a recommendation from the board and shareholder approval. The shareholders, however, are not permitted to approve a level of dividend above that recommended by the directors. How the rules on legal capital and the rules on distributions link is explained in the Companies Act 2006. Let us consider an example on how a company could arrange its profits distribution through dividends. Let's say Anna and Conrad have set up the company with 200 fully paid up £1 shares at an issue price of £1.50. The company will have a share capital of £200 and an extra £100 in its share premium account. The share premium, as we mentioned earlier, is the price at which they are actually sold. If Anna and Conrad intend to pay a share dividend of 10p per share, a total of £20, their company will need to have assets of £320 after amounts are set aside to cover all its liabilities. Why £320? Because the legal capital is already 300, 200 nominal value plus 100 share premium. It is useful to reiterate here that the share premium account is classed as an undistributable reserve by the Companies Act 2006. There are also some other funds that form part of the undistributable reserve. 1. Cash redemption reserve, used to hold funds that the company uses to repurchase or redeem its shares. 2. Cash set aside to cover liabilities from previous years. A company cannot assess dividends for each year, disregarding the fact that it may have carried liabilities from previous years. Please note that the above example represents a gross oversimplification of the legal framework around distributions, but it will do for our purposes at this stage. What happens if a distribution is made unlawfully? If a shareholder knows or has reasonable grounds for believing that a distribution is made in contravention of the rules, then the shareholder is liable to repay the cash or the value if the distribution was not in cash. The company can also request repayment in the common law on the basis that an unlawful distribution amounts to misapplication by the directors of corporate property. When the transferee has knowledge of the facts rendering the disposition ultra vires, that party is under a duty to restore the assets to the company. Due to the rules on directors' duties, the directors are also under a duty to compensate the company for losses suffered due to an unlawful distribution. Can a company reduce its capital? Remember that share capital includes the minimum capital and the share premium account. A company may wish to reduce its capital when it needs to buy out a retiring member, or to return to the personal representatives of deceased member his share of the capital, but has insufficient profits available to do so normally. Let us consider the following example. If company Anacon has initially raised £1 million by a share issue, but has traded unsuccessfully so that its net assets exceeding liabilities, are only £500,000. A reduction in the company's legal capital would mean that any profits earned in the future would be distributable, whereas without the reduction the excess assets would need to be built up to 1 meter again before a distribution is possible. The reduction therefore can benefit shareholders in the long run, when the company's fortunes pick up. All companies can apply for a reduction in capital to the court after a special resolution of their members. Can a company reacquire its own shares? The common law prohibited the company from acquiring its own shares, as this would result in a reduction in capital. Money flows out of the company into the hands of the shareholders. The key concern is that allowing repurchases gives the directors a tool to increase the value of their own holdings, and to increase their control of the company, on the assumption that they are major shareholders themselves. The Companies Act 2006 maintains the prohibition. There are, however, serious exceptions to this blanket prohibition. The Act does in fact allow repurchase in a wide range of circumstances. Section 694 in particular is very useful as it allows the company to repurchase the shares of a director or an employee upon termination of employment, or to meet the requirements of a potential investor in an unquoted company who wants assurances that he will be able to find a willing buyer if he wishes to realize his investment. It makes the investment liquid for non-listed companies, in other words. It is also worth mentioning that the Companies Act prohibits a public company, or its subsidiaries, from giving financial assistance to a person for the acquisition by that person of the company's shares, whether the assistance is given before or after the acquisition. For example, if Anna and Conrad set up Anacon plc and Bank Alpha lends bidder Beta £1 million to enable Beta to take over Anacon plc and Beta's parent guarantees repayment, it will be unlawful for any financial assistance to be given by Anacon plc when taken over to Alpha, Beta or the parent company towards the repayment of the £1 million. The test, however, is whether the company is a public one at the time when assistance is given. If Anacon plc re-registers as a private company, it could give financial assistance after the acquisition. This step is commonly taken in private equity buyouts. What happens if unlawful assistance is given? It is a criminal offence for the officers in default to authorize the assistance, and the company is subject to a fine. The agreement itself is unenforceable by either party to it. One of the key features of company ownership via shares is that different shareholders have different ownership stakes, often with different attributes. The usual situation is one of concentration of shares in the hands of a limited number of shareholders, with some having the bulk, and some a minor part of the company. As member decision-making is dependent, to a degree, on GM decisions, the holders of the majority of the shares, often a special majority, are in complete or near complete control. This is commonly perceived as a danger for those in the minority, but does not necessarily need to be so. For instance, one could counter that minority shareholders could free ride on the efforts of the majority by exerting little effort, meaning having little involvement, yet reaping the benefits of company success. The law recognizes, however, a series of limits on the ability of the majority to act opportunistically against the minority. One of the ways the law protects minority shareholders is by specifying in advance certain decisions that is not up to the majority to take. An example can be found in S.25, which specifies that a member is not bound by an alteration of the articles after the date when he became a member if the effect of the change is to require the member to take more shares in the company, or in any way increases the member's liability to contribute to the company's share capital, or otherwise to pay money to the company. Another example can be found in the common law rule that shareholders cannot ratify wrongdoings by a director which involve the appropriation of corporate property. Having a large number of outright prohibitions, however, is considered cumbersome and costly for enterprises. The law, therefore, for the most part, seeks to control process rather than substance, by using a large number of rules that specify how the shareholders are to decide, rather than setting out what they can and cannot decide. For instance, when a decision affects the rights of the shareholders under the Constitution, a supermajority, 75%, is normally required. Another approach lying between the substantive and the procedural is to require equal treatment of shareholders, via, for example, the sharing rule. For example, when a public listed company repurchases shares on the market, the listing rules require equality of treatment between the shareholders. Similarly, the common law requires that dividends to be paid equally to shareholders according to their shareholdings. Another element of protection is to enable individual shareholders to bring derivative actions with the assistance control of the court as mentioned above. The substantive and procedural approaches are used in combination here, by shifting the litigation authority outside the majority and placing it at the hands of the court, and by structuring votes at shareholder level by excluding the votes of interested directors, shareholders. Further, the listing rules for related party transactions exclude the related parties from voting on the decision in question and require that all reasonable steps are taken to ensure that the interested parties' associates do not vote either. Another powerful technique is giving the minority exit rights at a fair price if certain decisions they disagree with are taken by the majority. These exit rights are linked to shifts in the composition of the shareholder body, not business decisions, as for instance in cases where the identity of the controller of the company is changing. This is a wide-ranging right that is common in other legal domains as well. To use a domestically relevant example, under the Greek Constitution of 2008, compensation is offered to shareholders of nationalized enterprises, Art 106.4, and minority shareholders are even offered a buyout option in cases of part nationalization, where the government attains a controlling stake in the enterprise, Art 106.5. Two further protective techniques are a. Giving power to the court to review decisions of the majority to check if they are unfair to the company, and b. Treating shareholders at risk from the decision as a separate group whose consent is needed for the decision to go ahead. Let us have a look at each in turn. We start with the power of the courts to review company decisions that impact on shareholder rights. A key lever in understanding the functions of shares in voting mechanisms is to remind ourselves that shares are property rights. As such, members do not have to vote their shares with the interests of the company in mind. They can do as they wish with the property, which translates as, they can vote for their personal interests even if these are at odds with the company's interests. This is not to say, however, that controlling shareholders can do whatever they want and trample the rights of the minority. This is why directors, for instance, cannot vote their shares under certain circumstances. It has been established for a long time, for example, that the power to change the articles must be exercised bona fide for the benefit of the company as a whole because of the power the majority has to bind the minority. A great debate has developed concerning the possibility that the majority can in a compulsory manner expropriate the minority. The courts have determined that a provision in the articles allowing the majority to expropriate the minority could not be for the benefit of the company, but solely for the benefit of the majority. However, a provision allowing the directors to require the shareholders who competed with the company to sell their shares at a fair value was held to be beneficial to the company. While you may get the idea from a reading of the case law that the judgment of whether something is in the benefit of the company belongs to the court, it is for the members, not the court, to determine whether a resolution is for the benefit of the company, and that the court will intervene only if satisfied that the members have acted in bad faith. It is interesting to note when thinking about decisions leading to expropriation that the Companies Act requires a takeover bidder who has purchased 90% of the shares of the target company to compulsorily acquire the remainder. The second avenue in protecting minority shareholders is to place them in a separate class. In the case of voting at class meetings, these questions are focused on the interests of the class, rather than the interests of the company as a whole. Class rights are defined as separate rights belonging to a distinct group of shareholders. Legislation presumes that shares are to be regarded as being of one class where the rights are in all respects uniform, and giving the shares different names does not alter that fact. Remember that the Companies Act requires the separate consent of the class, usually by supermajority, to any proposal to alter the articles in a way that affects their class rights. A further avenue to protect shareholders from future alterations to their rights is the idea of entrenchment. Minority shareholders could ask for the inclusion in the company's constitution certain provisions that make certain types of changes very difficult. This is called entrenchment of rights. This is something, however, that can only be done at the point of company formation, or with the agreement of all the members. Therefore, it cannot be raised as a protective shield at any point in the company's life. Considering this weakness of the entrenchment strategy, it is considered preferable to protect minority shareholders by creating classes of shares carrying the relevant protection and giving them to the affected members. If this is done along with a variation of rights clause in the articles to the effect that the consent of the affected class is necessary for the alteration of protection, then the shareholders in question are insured against adverse changes. Also, procedural safeguards can be put in place that make the alteration of the articles practically impossible without the consent of the shareholder in question. For example, a provision can be put in place that for there to be quorum in the shareholder meetings, a class of persons needs to be present. If they are not, they can effectively veto any changes. Equally weighted voting rights can be provided for written resolutions, so that the persons in question control the process. How about contractual avenues to enhance shareholder protections? One method of improving controls on issues of corporate governance with the minimum of formality is to have shareholder agreements instituted between the members. The advantages of this approach are that a private agreement does not have to be filed at Companies House and it can remain private. But can a shareholder agreement also bind the company? In theory, a company can enter into binding contracts with anyone, including its shareholders. However, legislation provides that the company cannot contract away constitutional powers, like the power to alter the articles by special resolution. According to the courts, a provision in a company's articles which restricts its statutory power to alter those articles is invalid. Nevertheless, this does not preclude the company from entering into a previous contract on such terms that for the company to act upon its subsequently altered articles would involve a breach of contract. This means therefore that the company can enter into agreements with its shareholders and will have to compensate them for losses if the agreements are breached. This allows the company the freedom to determine its constitution and protects at the same time the contractual expectations of the other party. Agreements between shareholders only, not involving the company, have the disadvantage, however, that if the membership of the company changes, as the contract is bilateral, it is not binding on new members unless they specifically agree to be bound. Where those agreements relate to voting powers, some companies use the concept of a voting trust, which separates voting rights from financial interests in the shares. The voting is exercised by the trustees for their own purposes, while the income stream remains with the shareholders. The duties of the directors, as we have seen, are owed to the company. Any harm done by directors breaching their duties is harm done to the company, unless a special personal relationship, agency, advice, has been created between the director and particular shareholders. How can the company, however, safeguard its interests? How does the company decide to sue the directors, when it is run by the directors? Leaving decisions on litigation on the board runs the risk that directors will choose to protect their own, even when it is clearly in the interests of the company to pursue an action. While the board may be independent, or the offending directors no longer in charge, in case of takeover, or via the appointment of a liquidator, it still feels risky to leave litigation's decisions to the company's management. Most commonly, private law claims against directors will arise when a company is placed into liquidation or when there is a dispute between major shareholders. In the former case, a liquidator will assume control of the company and that liquidator will have a duty to assess the company's rights of action against former directors and, if necessary, enforce those rights to recover money for the company's creditors. In the latter case, a well-funded shareholder will often try to protect their commercial interests or exert pressure by threatening or taking a derivative action on behalf of the company against the company's directors, notwithstanding that any damages recovered from the directors will be paid to the company. The COVID crisis resulted in a strong increase in company failures. Financial failure remains understandably the number one cause for director claims. Those can come in the form of securities class actions and have a severe financial impact on the individual directors and the company as well. In most cases, the company won't be able to indemnify its directors, which illustrates the importance of risk transfer. Next to that, we see more shareholder derivative actions on behalf of the company targeting directors, which again results in a situation where the company will not be able to indemnify its directors. The amount of claims emanating from M&A activity remains high as shareholders feel misrepresented in selling or acquiring assets, especially in situations where a company has to sell assets fast in order to stay afloat. The area where we see the strongest increase in new claims is in relation to regulatory investigations. This trend is likely to continue. The common law recognizes the right of the shareholders by ordinary resolution to sue the company's directors for breach of duty. If the articles do not confer that power to the shareholders, they can still by special resolution seek to pursue an action, as a special resolution is equivalent to amending the articles. But how about individual shareholders initiating an action? This is called a derivative claim. An individual shareholder brings an action in order to benefit the company. This principle has been part of the law since Foss v. Harbottle 1843-67-189. Here, however, we have a similar problem with the option of leaving the decision to sue on the board. What is the guarantee that individual shareholders will be motivated by the company's interests, rather than their own? This is why the law sets strict limits to the derivative action. In the modern law, derivative claims can only be brought under the statute, not in the common law. Section 260 of the Companies Act 2006 provides that derivative claim may only be brought in respect of a cause of action arising from an actual or proposed act or omission involving negligence, default, breach of duty or breach of trust by a director of the company. The cause of action may be against the director or another person, or both. A member of a company who brings a derivative claim must apply to the court for permission. Permission, or leave, must be refused if the court is satisfied that a person acting in accordance with Section 172, duty to promote the success of the company, would not seek to continue. The derivative claims procedure we discussed covers the situation whereby the company suffers harm from the actions of the directors. When specific shareholders are harmed, however, and not the company, then a different action will be suitable to allow them to defend their interests. That action is known as unfair prejudice. Section 994 of the Companies Act provides that a member of a company may apply to the court by petition on the ground a. That the company's affairs are being or have been conducted in a manner that is unfairly prejudicial to the interests of members generally or of some part of its members, including at least himself, or b. That an actual or proposed act or omission of the company, including an act or omission on its behalf, is or would be so prejudicial. This section operates as a protective mechanism for shareholders not in control, either minority or equal partners. The statutory remedy is very wide-ranging and can cover any conduct of corporate affairs, including shareholders' voting powers and directors' powers. It also represents a significant change in judicial attitudes as to non-intervention in corporate affairs. Not only do these provisions offer better remedies than the common law, but also render unlawful certain conducts that were allowed before. Section 994 protects expectations and not only rights. Borrowing from public law, it is sometimes said that the section protects the legitimate expectations of the petitioner, though more recently the courts have preferred the private law phrase, equitable considerations. These expectations are not in a contractual form, but arise out of a fundamental understanding between the shareholders which formed the basis of their association. As most cases on unfair prejudice have to do with expropriation, the courts have clarified that a petitioner could not be said to have been treated unfairly if an offer was made to buy the shares at a fair price. In the absence of agreement, there was an independent way to determine the price of the shares. The expert making the determination did not offer objections. Both sides have equal access to information and to the expert. It is important to note that these provisions do not provide a unilateral exit right for minority shareholders, right for the members to withdraw their capital from the company. Compulsory purchase indeed is not a right for the minority, but a remedy for unfair prejudice by the company's controllers. An interesting question is whether a shareholder can skip over restrictions on derivative actions by bringing an action for unfair prejudice. The short answer seems to be no. The unfair prejudice petition is normally confined to relief in respect of harm personal to the minority shareholder. For harms to the company, the derivative claim remains the appropriate avenue, with all the safeguards in place. In this episode, we focused on the main avenues through which shareholders participate in the company's success, predominantly dividends, and discussed the rules determining how a company can handle its capital. We then looked at the main aspects of minority shareholder protection. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about the regulatory environment around securities issues and how mechanisms around debentures and guarantees can be utilized by investors in public companies. The discussion then takes a broader view considering the process of exiting the stock market through private equity buyouts. Without further delay, let us get started on the content of this episode, which focuses on the regulatory environment around securities issues and how mechanisms around debentures and guarantees can be utilized by investors in public companies. The discussion then takes a broader view considering the process of exiting the stock market through private equity buyouts. Regulation around securities, traded shares, aims to achieve the creation of a type of consumer law that protects the buyers of shares from being taken advantage of, in the same way that consumer law for the sale of goods ensures minimum standards of safety and quality are respected. Regulation also aims to achieve allocative efficiency, by helping the market reach the most efficient outcomes when these cannot be reached by pure market processes. This is done primarily by facilitating flows of information between firms and investors. There are two methods whereby regulatory intervention can have efficient outcomes. One is by emulating standard consumer law and safeguarding standards. The second is by mandating disclosure and then empowering the consumer to make the correct choices according to their wishes. We can summarize therefore by saying that sound and effective regulation is important for the integrity, growth and development of securities markets. The aim of regulation in outline is the protection of investors, to encourage the creation of markets that are fair, efficient and transparent, to ensure that the failure and collapse of individual companies, which cannot be avoided in market economies, does not lead to widespread instability in the financial system. Implementation and enforcement of the regulatory system is entrusted to a public body, i.e. the SEC in the US, and the FCA in the UK. A basic legal framework should include, as a minimum, an obligation on the issuer of securities to disclose all relevant information so that investors can make informed decisions, and contains rules to ensure that an issuer continues to make relevant information available. Further, an obligation should be placed on the issuer to treat all investors, and shareholders in particular, in a fair manner. Added to this, there should be an obligation on financial intermediaries to be organized and to operate in a way which safeguards the integrity of the market and protects investors. Rules designed to deter manipulation and other unfair trading practices will need to be present in all systems, regardless of compliance levels with the above rules. With this broad outline of the regulatory system in mind, we now move to consider in some more detail another aspect of corporate borrowing. This is through debentures or debenture stock and the types of charge that companies can issue to lenders as security. This supplements knowledge gained already on the way companies raise money in markets and links with considerations for investors in terms of positioning themselves appropriately against the risks of insolvency. Put simply, a debenture is the document that evidences or acknowledges the company's debt. The definition provided by S.738 of the Companies Act 2006. A debenture includes debenture stock, bonds and any other securities of a company, whether constituting a charge on the assets of the company or not. Therefore, a mortgage of freehold property by a company falls within the statutory definition as it is a security and a charge on its assets. A charge or security interest is a right in rem created by a grant or declaration of trust which, if fixed, implies a restriction on the debtor's dominion over the assets in question. In rem, in Latin, means the thing, as opposed to the person, in personam. Debenture stock is money borrowed from several different lenders on the same terms. Such lenders form a class, who usually have their rights set out in a trust deed. The trustee, often a bank, represents their interests as a whole. The trust deed will generally contain the terms that there is an obligation to pay the principal sum with interest, identify the security, if any, that is given for the loan, and the events that will trigger the enforcing of the security. Creditors will often require security from a borrower before lending money, so that in the event of a default on repayment the creditor can enforce the security interest. By requiring security from a debtor company, the creditor seeks to ensure priority over the general body of creditors should the company be wound up. The granting of security by a company does not mean that the title to the secured asset passes to the creditor. Instead, it creates an encumbrance on the property. The creditor gets a right to have the security made available by an order of the court. For companies, the most common species of charges given as security interests are fixed and floating charges. A company may grant a fixed charge to a creditor over certain property such as a piece of machinery. Such a charge is similar to a mortgage in that the rights of the creditor attach immediately to the property and the company's power to deal with the asset is restricted. A fixed charge gives the holder of the charge an immediate proprietary interest in the asset subject to the charge which binds all those into whose hands the assets may come with notice of the charge. A floating charge floats over the whole or a part of the charger's assets, which may fluctuate as a result of acquisitions and disposals. Corporate property that can be made subject to a floating charge includes stock in trade, equipment, and book debts, receivables. The distinguishing feature of a floating charge is that the company can continue to deal with the assets in the ordinary course of business without having to obtain the chargee's permission. A floating charge converts to a fixed charge over the assets within its scope upon the occurrence of a crystallizing event such as a default on repayment or the winding up of the company. The distinction between a fixed and floating charge assumes critical importance if the company goes into liquidation because of the ranking of charges against the general body of creditors. Distinguishing features of a floating charge are that it is a charge on a class of assets of a company present and future. That the class is one which, in the ordinary course of the business of the company, would be changing from time to time. By the charge it is contemplated that, until some future step is taken by or on behalf of those interested in the charge, the company may carry on its business in the ordinary way as far as concerns the particular class. In determining whether a charge is fixed or floating, the courts will look to the substance of the matter irrespective of what description the parties use to categorize it. Book debts are debts arising in a business in which it is the proper and usual course to keep books, and which ought to be entered in such books. It is common for a company to have debts continuously owed to it by customers for goods and services that the company has rendered. Rather than wait for payment, a company can borrow money from creditors against the debts that remain unpaid. A question that has frequently come before the courts is whether a fixed charge can be created over book debts. The answer is not obvious, and it depends on the circumstances of each case. The general rule is that security interests are prioritized according to the order of their creation. However, as we saw above, a feature of the floating charge is that the company can continue to deal with the charged assets in the ordinary course of business. Therefore, a fixed charge can be created which will take priority over an earlier floating charge. In order to protect their priority, floating charges can insert a so-called negative pledge clause in the charge that prohibits the chargor from creating a charge that ranks equally with pari passu, or in priority to the earlier floating charge. Such a restriction is not inconsistent with the nature of a floating charge. However, it should be noted that the subsequent chargee will not lose priority unless he has actual notice of the negative pledge clause. Mere notice of the earlier floating charge is not sufficient. Where there are competing floating charges, the governing principle is that the earliest created takes priority. However, the parties may agree that the company may create a subsequent floating charge which will take priority or rank pari passu with the earlier floating charge. Understandably, a creditor who is considering lending money to a company may wish to find out the extent of its indebtedness. Companies are therefore required to register certain details of mortgages over their assets, under S.859A Companies Act 2006. Part 25 of the Companies Act 2006 lays down the registration requirements. The principal obligations are contained in S.859, which provide that prescribed particulars of certain categories of charges created by a company, together with the instrument creating it, must be delivered to, or received by, the company's registrar within 21 days of the creation of the charge. Failure to deliver the particulars to the registrar within the 21-day period renders the charge void against CS.874, a liquidator, any creditor of the company. Note that the loan is not void for want of registration of the charge, but rather the failure to register results in the lender ranking as an unsecured creditor. Once registered, the charge is valid from the date of its creation. This results in what has been termed the 21-day invisibility problem. This is because whenever a person checks the register, it cannot be assumed that it is comprehensive because there may be a charge for which the 21-day period is still running. Section 859A also requires companies to maintain at its registered office a register containing certain prescribed particulars of all registrable mortgages. The failure to keep such a register does not affect the validity of the charge. When a charge is registered, the registrar must issue a certificate stating the amount secured by the charge. The certificate is conclusive evidence that the statutory registration requirements have been complied with. The charge cannot then be set aside if the particulars are incorrect. Registration is a perfection requirement. It does not determine priority, which, as we saw above, depends upon the date the charge was created. Creditors who ought reasonably to have searched the register will be deemed to have constructive notice of the charge. Rectification of the register may be possible where the court is satisfied that the failure to register within the required period, or that an omission or misstatement of any particular was accidental or inadvertent, or is not of a nature to prejudice creditors or shareholders of the company, or that on other grounds it is just and equitable to grant relief. S.873. Generally, Leave to register out of time is granted by the court subject to the rights of intervening secured creditors and provided the company is solvent. Section 245 of the Insolvency Act 1986 invalidates a floating charge created within 12 months, termed the relevant time, prior to the onset of insolvency unless it was created in consideration for money paid or goods or services supplied at the same time as or subsequent to the creation of the charge. The relevant time is extended to 2 years where the charge is created in favor of a connected person. However, S.245(4) provides that a floating charge created in favor of a non-connected person within the relevant time, i.e. 12 months, will not be invalidated if the company was able to pay its debts at the time the charge was created and did not become unable to do so as a result of creating the charge. It should be noted that this provision does not extend to charges created in favor of connected persons. The term connected person is defined by S.249 as a director or shadow director of the company, an associate of a director or shadow director of the company, and an associate of the company. The object of S.245 is to prevent an unsecured creditor obtaining a floating charge to secure his or her existing loan at the expense of other unsecured creditors. In addition to other methods of obtaining security for loans, or managing the risks of default of a counterparty, the provision of a personal guarantee over a loan is one of the primary methods of providing some security to a creditor that the debtor will meet their obligations. But what is the extent of the guarantor's liability? It is possible that a guarantor will be asked to cover the outstanding amount of the debt, but could also face claims to cover additional losses suffered by the creditor. This happens as the guarantor is promising the creditor that the principal debtor will perform their obligations. Once the principal debtor defaults, the guarantor is in breach of his own promise that the principal debtor will perform. The creditor can then sue the guarantor for damages. The measure of damages is the loss caused to the creditor by the breach of the principal debtor, which will usually be the total debt outstanding less a discount for accelerated receipt, getting all the money immediately, rather than it being paid over time. Where a guarantee is given at the request of the principal debtor, an indemnity in favor of the guarantor is implied. The modern explanation for this indemnity lies in the law of restitution. The principal debtor would be unjustly enriched if, having requested the surety to give a guarantee, he or she did not have to indemnify the surety in the event the surety made payment to the creditor. This right to an indemnity can be waived or modified by the contract of guarantee. Similarly, if a guarantor pays off the creditor in full, he or she is entitled to step into the shoes of the creditor and exercise all the rights of the creditor against the principal debtor. In practice, this means that the guarantor can sue the principal debtor, or take advantage of any judgment the creditor has against the principal debtor. Anything the creditor does to alter or extinguish the guarantor's rights to indemnity or subrogation will discharge the guarantor from liability unless the guarantee provides for the alteration, or the guarantor consents to it. It is important at this point to offer some further information on distinguishing between a guarantee and an indemnity. The two main reasons why it is important to distinguish between a guarantee and an indemnity are that indemnities are not covered by S.4 of the Statute of Frauds Act 1677, which means that an oral indemnity can therefore be valid, and a guarantee is an accessory or secondary contract. For the contract of guarantee to be valid, there has to be a valid contract between the creditor and principal debtor. If the contract between the creditor and principal debtor is, for some reason, void, the guarantor has no liability to the creditor. A logical extension of this is that the guarantor's liability is coextensive with that of the principal debtor. Another way of looking at this is to regard the guarantor's liability as a contingent liability. That is to say, the guarantor's liability is contingent on some event, normally the default of the principal debtor. An indemnity, on the other hand, is a primary liability. The indemnifier's liability is independent of the principal debtor's liability. The liability of the indemnifier can exceed that of the principal debtor. All this, of course, is subject to contractually negotiated terms and conditions. For example, a guarantor in a bank guarantee will often be described as the principal obligor. This is an attempt by the bank to make the guarantor's liability primary rather than secondary, combining elements of guarantee and indemnity in the same document through contractual means. How would liability under a discrete guarantee be quantified? Liability is quantified by the fixed amount outstanding between two companies. In the case of a continuing guarantee, since liability fluctuates according to the outstanding balance of the facility, some method is required to quantify liability at any given time. This can be done by a demand made upon one company by the other. The demand can be served unilaterally by the company, or may be served after the bank has served notice on the other to bring the guarantee to an end. You must also remember that a guarantee is a contract. The contract of guarantee must be properly formed. There must be consideration present, an intention to create legal relations must exist. Guarantees are subject to the normal rules concerning formation of contract. But what happens in case of variation of this contract? Some variations of the contract between the creditor and principal debtor, which are implemented without the consent of the guarantor, will discharge the guarantor from all liability under the guarantee, whilst others will only lead to a proportionate reduction. If a guarantor enters into a contract of guarantee on the basis that they are entitled to the rights of indemnity and subrogation referred to above, then the creditor and principal debtor cannot vary their contract without extinguishing their obligation, as the whole basis upon which the guarantor entered the contract has changed. An easy example is the creditor giving the principal debtor more time to pay. If a creditor does this, it prevents the guarantor paying off the debt himself or herself and seeking his or her indemnity from the principal debtor. Although there is no prejudice to the guarantor, his or her rights have been altered. We have already discussed the process via which a company can re-register from private to public and then seek to list its shares on a stock market. The opposite process is also possible, commonly encountered as a private equity buyout. A company can convert back to being a private company by a special resolution of its members making the necessary alterations to its name and articles and applying to the registrar. Why would this happen? A company could be forced to re-register if under S.648 its capital has fallen below the authorized minimum, by court order. Companies, however, may wish to take advantage of the limited disclosure expected of private firms, when they no longer need to raise funds. Private equity firms are good examples of private companies. Let us examine the reasons for coming out of stock market trading more closely. A public company may choose to go private for a number of reasons. An acquisition can create significant financial gain for shareholders and CEOs, while the reduced regulatory and reporting requirements private companies face can free up time and money to focus on long-term goals. Because there are advantages and disadvantages to going private as well as short and long-term issues to consider, companies must carefully weigh their options before deciding. A take-private transaction means that a large private equity group, or a consortium of private equity firms, purchases or acquires the stock of a publicly traded corporation. Because many public companies have revenues of several $100 million to several $1 billion per year, the acquiring private equity group typically needs to secure financing from an investment bank or related lender that can provide enough loans to help finance and complete the deal. The newly acquired target's operating cash flow can then be used to pay off the debt that was used to make the acquisition possible. Let's look at the factors that companies must factor into the equation. Being a public company has its advantages and disadvantages. On the one hand, investors who hold stock in such companies typically have a liquid asset. Buying and selling shares of public companies is relatively easy to do. However, there are also tremendous regulatory, administrative, financial reporting and corporate governance bylaws to comply with. These activities can shift management's focus away from operating and growing a company and toward compliance with and adherence to government regulations. Public companies must also conduct operational, accounting and financial engineering in order to meet investors' quarterly earnings expectations. This short-term focus on the quarterly earnings report, which is dictated by external analysts, can reduce prioritization of longer-term functions and goals such as research and development, capital expenditures and the funding of pensions, to name but a few examples. Investors in private companies may or may not hold a liquid investment. Covenants can specify exit dates, making it challenging to sell the investment, or private investors may easily find a buyer for their portion of the equity stake in the company. Being private frees up management's time and effort to concentrate on running and growing a business, as there are no stock market regulations to comply with. Thus, the senior leadership team can focus more on improving the business's competitive positioning in the marketplace. Internal and external assurance, legal professionals and consulting professionals can work on reporting requirements by private investors. Private equity firms, that have large pools of funds at their disposal, are the usual instigators of processes that bring large public companies back to the private domain. These firms have varying exit timelines for their investments depending on what they have conveyed to their investors, but holding periods are typically between 4 and 8 years. This horizon frees up management's prioritization on meeting quarterly earnings expectations and allows them to focus on activities that can create and build long-term shareholder wealth. Management typically lays out its business plan to the prospective shareholders and agrees on a go-forward plan. This covers the company's and industry's outlook and sets forth a plan showing how the company will provide returns for its investors. For instance, managers might choose to follow through on initiatives to train and retrain the staff or seek efficiencies through reductions in staff costs. The extra time and money private companies enjoy from decreased regulation can also be used for other purposes, such as implementing a process improvement initiative throughout the organization. Equity groups also need to provide sufficient returns for their shareholders. Leveraging a company reduces the amount of equity needed to fund an acquisition and is a method for increasing the returns on capital deployed. Put another way, a company borrows someone else's money to buy the company, pays the interest on that loan with the cash generated from the newly purchased company, and eventually pays off the balance of the loan with a portion of the company's appreciation in value. The rest of the cash flow and appreciation in value can be returned to investors as income and capital gains on their investment after the private equity firm takes its cut of the management fees. When market conditions make credit readily available, more private equity firms can borrow the funds needed to acquire a public company. When the credit markets are tightened, debt becomes more expensive and there will usually be fewer take-private transactions. Due to the large size of most public companies, it is normally not feasible for an acquiring company to finance the purchase single-handedly. But why would shareholders wish to sell to someone seeking a private equity buyout? Investment banks, financial intermediaries and senior management build relationships with private equity in an effort to explore partnership and transaction opportunities. As acquirers typically pay at least a 20 to 40% premium over the current stock price, they can entice CEOs and other managers of public companies, who are often heavily compensated when their company's stock appreciates in value, to go private. In addition, shareholders, especially those who have voting rights, often pressure the board of directors and senior management to complete a pending deal in order to increase the value of their equity holdings. Many stockholders of public companies are also short-term institutional and retail investors, and realizing premiums from a take-private transaction is a low-risk way of securing returns. In considering whether to consummate a deal with a private equity investor, the public company's senior leadership team must also balance short-term considerations with the company's long-term outlook. They will ask themselves whether taking on a financial partner makes sense for the long term, how much leverage will be tacked onto the company, whether cash flow from operations be able to support the new interest payments, what is the future outlook for the company and industry, and whether these outlooks are overly optimistic, or are they realistic. A private equity firm that adds too much leverage to a public company in order to fund the deal can seriously impair an organization in adverse scenarios. For example, the economy could take a dive, the industry could face stiff competition from overseas, or the company's operators could miss important revenue milestones. If a company has difficulty servicing its debt, its bonds can be reclassified from investment-grade bonds to junk bonds. It will then be harder for the company to raise debt or equity capital to fund capital expenditures, expansion, or research and development. Healthy levels of capital expenditures and research and development are often critical to the long-term success of a company as it seeks to differentiate its product and service offerings and make its position in the marketplace more competitive. High levels of debt can thus prevent a company from obtaining competitive advantages in this regard. Further, many private equity buyouts have been little more than asset stripping, where the new acquirer, hidden behind the relative lack of transparency of a private structure, aggressively cuts costs, disposes of valuable assets, and then leaves the husk of the company behind once all value has been extracted. To avoid these pitfalls, a company's current management needs to scrutinize the track record of the proposed acquirer and examine the extent to which the acquirer is aggressive in leveraging similar newly acquired companies, the extent of their familiarity with the industry, their financial plans and projections, whether they aim to replace management, and what is their medium to long-term exit strategy. In conclusion, one could argue that a take-private transaction is an attractive and viable alternative for many public companies. As long as debt levels are reasonable and the company continues to maintain or grow its free cash flow, operating and running a private company frees up management's time and energy from compliance requirements and short-term earnings management and may provide long-term benefits to the company and its shareholders. In this episode, we focused on the regulatory environment around securities issues and discussed how mechanisms around debentures and guarantees can be utilized by investors in public companies. The discussion then took a broader view of the process of exiting the stock market through private equity buyouts. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about issues relevant to those wishing to raise capital outside equity and debt markets. We discuss available sources of funding for business and offer an introduction to bank borrowing. We also address alternatives to bank borrowing such as invoice discounting, factoring, finance leases and hire purchase before offering a short reflection how company insider interests are aligned in promoting the interests of the business in the context of fundraising and expansion. The episode finishes with a presentation of cryptocurrencies and a discussion on how they could be of use, or perhaps not of any use, to those seeking to fund expansion of their business. Without further delay, let us get started on the content of this episode, which focuses on issues relevant to those wishing to raise capital outside equity and debt markets. We discuss available sources of funding for business and offer an introduction to bank borrowing. We also address alternatives to bank borrowing such as invoice discounting, factoring, finance leases and hire purchase before offering a short reflection how company insider interests are aligned in promoting the interests of the business in the context of fundraising and expansion. The episode finishes with a presentation of cryptocurrencies and a discussion on how they could be of use, or perhaps not of any use, to someone seeking to fund the expansion of their business. There is a variety of reasons why a company may wish to raise money. Let us take the example of Anna and Conrad. Once they have set up their business and started producing their innovative water sprinkler, they may wish to accelerate their progress. It could be that they wish to purchase new machinery or obtain new premises. This is known as capital expenditure. They may wish to fund the acquisition of another business, or to pay employee wages and other overheads, known as working capital, or perhaps they seek to fund additional research and development, for example to pay for the costs of a patent application. There are plenty legitimate reasons therefore why a business, new or established, may wish to raise funds. Businesses can in fact raise money in many ways. Possible sources of funding could include retained profits, bringing in investors as shareholders, equity investors, or take a loan or issue a debt security or bond, debt investors. Accelerated development cannot take place through retained profits, which implies that the business saves money gradually in order to invest in the future. Also, a business cannot use retained profits as funds if it has limited or no profits. Further, retained profits are often unsuitable to fund acquisitions simply due to the volume of funds needed. Speedier expansion requires the insertion of funds from an external source. In our other lectures, we have already discussed raising money through the equity route, either by incorporating, or going public, or listing in a stock market. For this reason, this lecture will focus on contractual avenues, borrowing and other debt-based tools to raise finance for corporate expansion. Banks will investigate a number of factors when deciding whether to lend the money and to determine the cost at which they will lend the money. A bank will often be more prepared to lend, and lend at a lower cost, if adequate security can be provided. This means that if someone can put up collateral for a loan, then it is both easier to obtain the loan and cheaper to do so. For example, if Anna and Conrad already own the building out of which they run their business, offering the property as collateral would significantly enhance their chances of being approved for a bank loan to expand the business. A second consideration is the reputation of the potential borrower. Startup businesses are exciting ventures to invest in, but also have high failure rates. Banks may be inhibited from lending to a new venture or may ask for higher returns to make taking additional risks worthwhile, therefore increasing the cost of borrowing for the business. A third consideration will be the historic performance of the borrower. The bank will want to see previous accounts and a business plan to assure itself that this business has been successful in prior projects and repaid earlier loans and met obligations in similar projects. Crucially important will be the company's credit rating, as a bank will undertake a credit check with one of the major credit reference agencies if the company has been in operation already. Finally, the purpose for which the money is to be used will be the ultimate consideration, and the riskier the purpose for the loan, the less likely the bank will be willing to lend. We can explore the terms negotiated in a loan agreement by assuming the following. Anacon Limited seeks to borrow £5 million from London Bank plc. Anna and Conrad, the directors of the company, have questions on the schedule of repayments, on whether interest will be fixed or variable and the mode of calculation, and whether early repayment is an option. It is possible to structure a loan agreement whereby the company does not start repaying the loan immediately, but only pays the interest for the first 5 years, before starting to repay the principal amount. It is also possible that a loan can be repaid at the end of a period plus interest in what is called a bullet repayment. On whether the interest is fixed or variable and its method of calculation, there are various options. Interest on commercial loans is nearly always variable. Interest will either be calculated with reference to the Bank of England base rates or the Sterling Overnight Index Average, SONIA. SONIA is published and administered by the Bank of England and is the market standard brought in to replace LIBOR, London Interbank Offered Rate, the rate at which banks lend to each other, that was wound down after a collusion scandal in the UK in 2012. If the interest of the bank loan is calculated according to SONIA, London Bank will borrow money from other banks at this rate and then charge the borrower a top-up rate above, which represents the bank's profit margin. With smaller loans, the bank funds borrowing from its own deposits, so bases interest on its own base rates, which are likely to be based on the Bank of England ones rather than a market standard. It is worth noting that fixed rates for the duration of a loan are a rarity in the UK, something that is particularly obvious in the residential mortgage market, where there are hardly any products offering fixed rates beyond 5 years. There are historical reasons for this, but the result is that the bulk of interest rate risk is passed on to the borrower, with potentially destabilizing consequences in case of a financial crisis affecting property values. As to the right to repay early, a company will usually have a right to repay early. However, there might be financial penalties in doing so. If a bank has borrowed money from its own depositors, it has committed that money to lend to the company. If the company repays early, this means that London would not get the full interest payment from the company, thus reducing its margin, profit. With SONIA calculated rates, London Bank would borrow money for short periods from other banks. This means that the bank would be less incentivized to offer an early repayment option, and Anacon Limited may not want to assume the increased cost of including this capability in its loan agreement. Most of us think of borrowing as taking a loan or an overdraft from a bank. Many companies do borrow on this basis, but commercial companies can also effectively, and crucially more cheaply, raise finance by other means. A common method is the sale of obligations involving funds incoming to the company. A great deal of finance arrangements are built around this, under the general term of receivables financing. But what counts as a receivable? Car loans, insurance premiums, credit card debts, secured consumer loans, equipment loans, freight rentals, rentals from real and personal property, and debts, all count as assets of a business. They are essentially money owed to a business, that will at a specified point in time reach its accounts. The idea behind leveraging these incoming assets as sources of finance is that a business can either sell its receivables or use them as security for borrowing. For example, if Anacon Limited sells successfully, its water sprinklers will be owed debts by purchasers of its products when there are outstanding invoices. The company could sell or mortgage these debts to raise finance. Further, given the nature of the company's business, it is likely that the company owns intellectual property rights, patents, trademarks, etc. If the company allows others to use these rights, it might also receive royalty payments. The right to these royalty payments could be sold or mortgaged to raise finance. This is why we said earlier that receivables financing is about using any and all incoming streams of funds as a way to accelerate money flowing into the business. This, of course, comes at a cost, as the company will receive less funds to obtain them quickly than it would have received if it waited for the normal time for the assets to come in. Accelerating time is the whole point, however, as the company will have the opportunity to put these funds to productive use and hopefully generate earnings that will overshoot any costs involved in obtaining financing. We can examine how the process works into some more detail by explaining the concept of factoring. In a factoring agreement, a company sells its debts for less than face value to a factoring company. The company becomes the borrower, and the factoring company is the lender. The factoring company immediately pays the borrower the discounted sum. The factoring company then collects the debt from the debtor and make a profit off the recovered debt. For example, our Anacon Limited might factor a £100 invoice issued to a client who bought a pack of water sprinklers. It would sell the invoice, for example, for £90 to the factoring company, who would immediately pay Anacon Limited £90. The factoring company would then collect the £100 invoice payment when it comes due and make its profit off the £10 difference. Factoring is a form of what we described above as receivables financing. There are, of course, multiple variations of the above arrangement, and sometimes the factor will charge a fee paid by the company over and above the profit they make by discounting the funds the company receives. We will now look at factoring in more detail and unpack some of the terminology you may come across. It is worth exploring the difference between factoring and what is known as invoice discounting, a more basic version of the concept behind factoring. If debts are factored, the factor not only buys receivables from the client, it also offers a debt collection service for the client as well. No debt collection service is provided in an invoice discounting arrangement, as all the lender does in this case is buy the receivables. In the latter case, invoice discounting, the debtor, the person who has the initial payment obligation towards the company, may not know at all that another entity is due to receive their payment. Factoring involves notifying the debtor that the factor has purchased the debts. With invoice discounting, no such notification is given. Invoice discounting is generally perceived to be riskier for the lender. Invoice discounting is riskier because if the debtor has not been notified that the debts have been assigned to the factor, the debtor can discharge the debt by paying the company directly. If the company goes insolvent before it has the chance to clear the funds to the lender, then the risk of default is entirely borne by the lender. Another key distinction is the one between recourse and non-recourse factoring. With non-recourse factoring, the factor will buy the debts from the company as they arise and will not be able to return to the client if the debtor fails to pay the factor. Clearly, this is risky for the factor. In order to protect themselves, the factor might have to approve the types of invoices that they will buy. Alternatively, the factor could require the payment of a fee to protect against non-payment by debtors, meaning that some of the cost of non-payment is passed back to the company. With recourse factoring, the factor can compel the company to repurchase the debt if the factoring company is not paid. It is worthwhile noting that if the company commits a major breach of the factoring agreement, the factor will also be able to compel the client to repurchase any unpaid receivables. It is probably obvious from the above information that factoring is most suited to businesses that are unlikely to encounter disputes over pending invoices. For example, disputes are common in the construction industry and factoring is rare there. Factoring tends to be more common in the manufacturing, transport and distribution sectors. Even though, in the context of the pandemic crisis, one would not want to be buying debt generated in the tourism industry. Fast-growing businesses will often factor their debts to improve liquidity. As we mentioned earlier, a fast-growing company may want to buy more stock to fulfill orders, but it might not be paid quickly enough by its existing to afford the new stock. A factoring arrangement will improve cash flow and facilitate stock and capacity expansion. Also, businesses with poor or underdeveloped debt collection systems might find factoring attractive if the function of collecting on debts is assumed by the factor. Of course, every financial arrangement entails a degree or risk. For instance, as factoring is based on purchasing debts usually represented by an invoice, an unscrupulous company could create invoices based on fake transactions. This is known as fresh air invoicing, and is used to defraud the factor into paying the company where no underlying assets exist. Factors have rights to check and investigate their clients' invoices in order to prevent this happening. An example of these risks is presented in the case of Official Receiver v. Doshi from 2001, where the defendant was disqualified from acting as a company director on account of his perpetration of a deliberate fraud in that he raised false invoices to the tune of £2.69 million in order to obtain finance for the company. The director in question was found liable to contribute to the company's assets funds in respect of debts incurred after the date he ought to have realized that the company could not have survived without his fraudulent invoicing. Assume that a company needs an asset for its business, but it does not have enough cash to buy the asset and cannot borrow money from a bank to buy it. Another way that the company might acquire the asset is through vendor financing. The essence of vendor financing is that the seller of the asset provides the buyer with facilities to buy the asset. Assume that a company was given a 31-day credit period. These types of borrowing involve suppliers who extends credit for a period to a buyer, effectively allowing them to borrow the purchase price for the duration of the credit period. If you think about it, this is the seller of goods effectively lending the company the purchase price of the goods for 31 days. The most common types of mechanisms through which companies can raise finance is through finance leases and hire purchase agreements. The essence of both finance leases and hire purchase is that an asset is acquired by someone other than the company, but for the company's use. The company, instead of purchasing an asset, leases it instead from a finance company and can use it, but does not have to incur the upfront costs of acquiring it. The company will pay in installments for the use of the asset over a period, till the agreement period reaches its end, or eventually acquires the asset. Let us assume that Anacon Limited needs use of machinery that costs £1,000 and which has a 3-year working life. The company could lease the asset from a finance company instead of paying for it up front, which could necessitate a bank loan or overdraft. After 3 years, the company would have had the asset for all its working life and paid less for it than the £1,000 purchase price. This arrangement has the same economic effect as if the company had used a bank loan to acquire the asset, but may cost less than servicing a bank loan. Finance leasing is a form of vendor financing, where the seller of the equipment offers a pay-by-installments facility. Common types of finance leasing are hire purchase and conditional sale agreements. These types of arrangements are similar to a loan facility. In both cases, a buyer pays for goods by installments, similar to repayments on a loan. The credit facility is provided by the seller. Types of finance leases include a finance lease and an operating lease. Under a finance lease, the company will hold the asset for the whole of its working life. It is the equivalent of purchasing the asset, the rental payments being effectively the same as the repayment of principal and interest under a loan. Under an operating lease, on the other hand, the company holds the asset for a fraction of its working life. Finance leases are used to acquire assets ranging from planes to photocopiers. Anybody who has rented a car on holiday has been the lessee under an operating lease. The advantages of leasing are that it is easier for the seller or finance company to retake possession than a lender, such as a bank, could enforce security. They give the company access to credit facilities it possibly would not otherwise have. There may be tax advantages, as the installment payments are deductible expenses, and if a company uses a lease to acquire an asset, it might be a way around any borrowing restrictions in the company's constitutional documents or embedded in bank facilities with its other creditors. There are also disadvantages, however, primarily the fact that the company does not own the asset and the fact that it will, in most circumstances, bear the cost of maintenance and upkeep, even though it does not own the asset. On the assumption that Anacon Limited has already an asset base and is in need of raising finance, another avenue would be available to them, that of sell and leaseback agreements. This is a type of financing that is attractive to businesses with a large asset base but limited liquidity. The way it works is by selling a significant capital asset, a large machine, expensive IT equipment or vehicles, to a finance company and leasing them back. The finance company offers cash for the purchase of the assets that the company can use immediately, and then makes a profit as some interest is built into the leasing agreement and the payment schedule. The reason why this technique is mentioned last is that it is unlikely to be of value to a new company that is scaling up, plus it tends to be an expensive way to draw credit, possible uncompetitive in comparison to bank loans. Who should make decisions on financing, and how does the law ensure that the board of directors is acting in the interests of the company and the shareholders? Despite the importance of these issues and the significance of aligning directors' objectives to various interests, the law takes a fairly relaxed approach to the structure and composition of the board of directors and the board's position in relation to shareholders, senior management, and external actors. Most corporate governance codes have indeed focused on the composition of the board, executive versus non-executive directors, and less on imposing organization structures on companies. Also, while corporate governance is focused on the balance between directors and managers, company law is focused on regulating the actions of the board of directors, only part of the management structure. For all types of companies, private and public, the directors, subject to the articles, are responsible for the management of the company's business, for which purpose they may exercise all the powers of the company. Mention of management here refers to the strategic direction of the company and not as to everyday management, which as discussed in the code is a matter for professional executive managers that may or may not be directors of the company. Governance problems are of lesser significance in private companies where there is likely to be a closer connection between the board and the shareholders, roles often overlap, and it is possible that the articles provide that certain decisions can be taken only subject to shareholder consent, even if no such requirement is present in the Act. The general meeting of the shareholders is the central core decision-making body of the company, and the source of its power. Even though this power can be delegated in a way that management is controlled by the directors, the power of the general meeting to guide the company can allow it to make decisions when, for instance, there is a deadlock on the board. However, this power can be exercised when there is a real block, and there is no adequate mechanism in the articles to reconstitute the board so it can continue with its management role. The general meeting has therefore residual powers to act, so that the board can refer decisions to be made by it, on the assumption that the articles allow this. An act of the directors that is voidable can be ratified by the company in general meeting if the act is within the powers of the company and the meeting acts freely and with full knowledge. It is also established that the shareholders may bind the company by unanimous agreement, all shareholders entitled to vote, not just attendees at the meeting. There is some authority that suggests this to be possible, even in matters which the Constitution allocates to the board. This is a less problematic case than the general meeting ordering the board, as it does not raise issues about the protection of minority members. Everyone agrees in this case. Can cryptocurrencies offer solutions to business finance needs? And would they be of use to someone in the position of our inventors Anna and Conrad? Cryptocurrencies such as Bitcoin, BTC, and Ethereum, ETH, are recognizable financial tools around the world, and some of them have been in circulation for over a decade already. One of the key features of cryptocurrencies is their decentralized control, which allows them to act as an alternative to conventional centralized banking systems. These instruments offer innovative and potentially disruptive methods of payment, in contrast to more traditional forms of money. Cryptocurrencies are global and could, but this is subject to a lot of debate, facilitate swift transfers across borders, without the involvement of state authorities or private banks. The way this works is through transfer from and to electronic so-called wallets secured by encryption. In principle, this allows for full anonymity of ownership and use, with encrypted accounts capable of being traced back to their owners while remaining anonymous for practical purposes. Bitcoin is perhaps the best-known example of these currencies, raising in value from nearly zero at launch in 2009 to nearly $63,000 in October 2021. Value in crypto can thus be held and exchanged without the public disclosure of personal identity. Consequently, transactions in cryptocurrencies are much less open to social and political pressure than exchanges in physical currencies. Such opacity obviously raises concerns as to the legality of funds invested in crypto and the ability of the regulatory system around money laundering to effectively police this space. As cryptocurrencies do not require banks and clearinghouses, they are seen as disruptive innovators to the entire industry of finance. In traditional banking, when parties are not familiar with one another, there is need for trust in mediating individuals or institutions as facilitators and guarantors of the respective transaction. This trust element is supplied by intermediaries, such as banking regulators, central banks, regulated markets, and clearing services. Through an impersonal verification technology, cryptocurrencies offer an alternative system, whereby transparency and credibility is maintained without a strict necessity to involve expensive transaction costs in digital peer-to-peer transfer systems at close to zero, or cumbersome mediators. In practice, however, to pay for the maintenance of security standards, even crypto exchange platforms charge fees, albeit at considerably lower levels than what conventional banks and financial service providers demand for exchanges of comparable value. Cryptocurrencies have the capacity to replace the centralized generation and dissemination of means of payment through public institutions or private issuers with a considerably more decentralized process. As such, they represent a challenge to the state-controlled or influenced money supply in any given jurisdiction. Governments or banks cannot directly control the overall availability of digital coins, other than participating themselves in the process of mining alongside private actors. As a result, the power of financial and political institutions over the available quantity of a respective currency is significantly reduced. While states cannot control the supply of crypto, they can penalize its users and generators when they are within a jurisdiction, as is the case currently in a number of countries that have attempted to ban cryptocurrencies, most notably China in the autumn of 2021. Considering this background before, would crypto offer financing opportunities to Anna and Conrad, and the nascent company Anna Con Limited? Cryptocurrencies such as Bitcoin and other digital currencies are not backed by real assets or tangible securities, and as we have seen, they are traded between consenting parties with no broker and tracked on digital ledgers. As an investment, they represent a high-risk asset with wildly fluctuating value. As a store of value, they are very high risk, as they do not operate in consistently liquid markets. The main function of crypto for a new business could be as an exchange rate hedge in those countries with volatile currencies or capital controls. Of course, the problem with this would be that these are the countries that have attempted to ban cryptocurrencies precisely to block their use for this purpose. Crypto, despite all the hype, is not really useful for an actual business with transactions in the real world, and while it could be used as a high-risk investment for businesses with an excess of funds, crypto in itself cannot be used to raise money for investment in an expanding business. Other avenues for raising finance using online domains, such as crowdfunding, could be a lot more relevant to Anna and Conrad. For investors, crowdfunding apps and websites offer the chance to make money by investing in small, fast-growing businesses. For entrepreneurs, they can be a great way to raise a business's profile while generating cash at competitive cost. Crowdfunding lets small businesses and individuals raise money from investors, the crowd, who all invest small amounts in the business or cause. This method of pooled financing started as a way to fund creative projects such as films, theater projects, and music recordings, but has expanded to allow almost anyone to raise money from friends, family, or complete strangers. The two most common types of crowdfunding which can appeal to investors as a way to make money are loan-based crowdfunding, which is also known as peer-to-peer or P2P lending. Using this method, one can lend money to individuals or businesses via a platform in exchange for a set interest rate. Investment-based crowdfunding, on the other hand, involves investing in a company and obtaining an interest in the business, either in the form of equity or products or services. Popular P2P platforms include Zopa, Funding Circle, and Stepladder, who specifically target people looking to raise finance for property transactions. Two of the biggest investment-based platforms in the UK are Crowdcube and Seedrs. Remember, however, that all types of crowdfunding are considered high-risk investments, as there is no guarantee one will receive the return on their investment they were hoping for or obtain the product you were promised. The biggest risk with investment-based crowdfunding is that the company goes insolvent, wiping out the value of any equity obtained. The main risk with P2P lending is that borrowers default on their repayments. Another danger is that the platform that facilitates the investments itself fails, which could make it impossible to recoup any funds invested. Bridging the gap between cryptocurrencies and crowdfunding could be achieved by a company launching its own cryptocurrency. Initial coin offerings, or ICOs, could be an alternative to crowdfunding or equity fundraising. This, admittedly, however, is not a viable route for a startup company, like the one of Anna and Conrad that is our core example. In this episode, we focused on issues relevant to those wishing to raise capital outside equity and debt markets. We discussed available sources of funding for business and offered an introduction to bank borrowing. We also addressed alternatives to bank borrowing such as invoice discounting, factoring, finance leases, and hire purchase before offering a short reflection how company insider interests are aligned in promoting the interests of the business in the context of fundraising and expansion. The unit finished with a presentation of cryptocurrencies and a discussion on how they could be of use, or perhaps not of any use, to someone seeking to fund expansion of their business. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about issues relevant to issues of security in investments. We discuss the meaning of security in financial transactions and the methods via one may obtain it. We explain the function of quasi-proprietary rights and how they can serve to secure a loan or ensure the repayment of some debt. We also discuss guarantees, indemnities, and other contractual mechanisms such as retention of title clauses. We conclude with a reflection on cryptocurrencies as security mechanisms and on what could be used to secure against the volatility in the price of cryptocurrencies themselves. Without further delay, let us get started on the content of this episode, which focuses on issues relevant to the security of investments. We discuss the meaning of security in financial transactions and the methods via one may obtain it. We explain the function of quasi-proprietary rights and how they can serve to secure a loan or ensure the repayment of some debt. We also discuss guarantees, indemnities, and other contractual mechanisms such as retention of title clauses. We conclude with a reflection on cryptocurrencies as security mechanisms and on what could be used to secure against the volatility in the price of cryptocurrencies themselves. Security is a key aspect of negotiating commercial transactions, particularly, and a significant component of investing in financial markets. Security in this context means building protection against risk. A contracting party will seek protection against several potential risks connected to any transaction. In fact, in finance, a lot of activity has to do with evaluating, assessing, and protecting against risks. The expression, taking security, refers to the use of any one or more techniques employed by contracting parties to protect themselves against the risk of the other side to their bargain failing to perform its contractual obligations. Also, one should consider whether they need protection against the eventuality that the transaction becomes unenforceable for another reason, or even that the transaction generates a loss. Under English law, security can be taken in several forms using common law or equitable devices which may give rise to proprietary rights or to merely personal rights depending on the structure of the security mechanism employed and the circumstances surrounding the contractual bargain in question. The court in Re Paramount Airways Limited from 1990 stated that security is created where a person, the creditor, to whom an obligation is owed by another, the debtor, by statute or contract, in addition to the personal promise of the debtor to discharge the obligation, obtains rights exercisable against some property in which the debtor has an interest in order to enforce the discharge of the debtor's obligation to the creditor. It is important that you remember the two types of security as personal security and security over property. The first one can be described as a situation where a person who is not otherwise liable under a contract with the creditor assumes some form of liability to ensure that the creditor gets paid if the debtor fails to perform his or her contractual obligations. The most common example is a guarantee. In the second case, security over property, the creditor gets a right relating to property, which can be land-based, known as real property, but may also be other types of property such as specific goods. The main effect that the taking of security may have is that it coerces the debtor into paying the amount since the debtor will not wish the creditor to take away the secured property. For example, if you hand over a valuable watch or piece of jewelry to a pawnbroker, you will want that item back, so you will be incentivized to repay the loan. You do not want your bank to take possession of your house, so you make sure that the mortgage installments are paid every month. If the debtor becomes insolvent, the creditor with security is usually in a better position to get paid since the creditor can sell the security to realize the debt. A creditor who has security can usually prevent other creditors taking those goods to pay off their debts. If the debtor sells property subject to security, the creditor may be owed that money by the buyer or may be able to lay claim to the money in the hands of the debtor. A secured creditor has a right of pursuit, which means that they can follow the asset which is the subject of the security into the hands of third parties. A secured creditor also has a right of preference. In other words, the secured creditor is entitled to look to the proceeds of the asset to satisfy his or her debt in priority to the claims of other creditors in the case of insolvency of the debtor. Let us offer some further explanation on terminology. A proprietary right is a right over property, whether in the form of absolute title, outright ownership of all resulting rights, or title recognized in the common law, right of trustee under trust, or equity, rights of beneficiary under trust. There are two types of security over property: possessory security and non-possessory security. In the first case, the creditor takes physical possession of the property. Perhaps the most common example is where goods are pawned to a pawnbroker as security for a loan, known in English law as a pledge. Pledges grant the secured party, creditor, a right to possession of the pledged property by not to ownership of those assets. The secured party retains possession of that property until the pledger performs its obligations under the contract between the parties. Liens typically arise by operation of law without the need for the consent of both parties, with the exception of contractual liens, and entitle the right holder to retain property in her possession until a payment to which she is entitled from the owner of the property is made to her. A lien therefore secures payment without necessarily transferring title initially, although the right holder may be entitled to sell the property to generate funds to make the payment owed to it. In the case of non-possessory security, the creditor does not take possession of the property. The most common example of this type of security is a mortgage on a house. A proprietary right can be enforced against third parties at will, regardless of whether the person in possession of the property goes insolvent or passes on the property, as the rights follow the goods or real estate and are not linked to the identity of the owner, but burden the person having possession. Remedies for proprietary rights are also significantly elevated in comparison to those available for personal rights. A personal right will be a purely contractual right that does not give rights to property, but only a right to recover money or to perform some action. In selecting the type of security appropriate to each deal, a party will structure its security by choosing from a range of available tools employed to achieve an objective and then draft and organize the contractual terms that bring the arrangement into being. As is becoming evident from the information presented here, such choices can be highly significant. When we talk of tangible property, we generally mean land and goods, while intangible property includes a number of different types of property, with the two most common being receivables, debts owed to other creditors. Banks will often take as security the debts owed to the business to which they are making loans, those that the business is due to receive, and lay claim to investment securities such as shares or bonds. These are often in dematerialized form, meaning that the share is recorded and can be traded, bought and sold, electronically instead of in paper form. Consensual security means that it has been created by agreement, a contract, between the parties. In some cases, the law may impose security, such as in the case of some liens, which, as we saw above, are basically a right to retain possession of some item belonging to another, for example documents. Real security, as intangible or material, gives the holder of the security, usually the creditor, rights in the asset itself which are binding on third parties. You will also come across the term quasi-security, which, although it is intended to perform a similar function, does not give rights in the asset which can be enforced against third parties. More on this quasi-security later on in this episode. We will now present the core techniques of taking security, starting with taking title in some property. This can be done in several ways. Title could be transferred to a piece of property that the lender keeps as insurance. If the debtor does not pay, then the lender is free to do as he wishes with the property. The contract will usually specify that the property will be returned, or its value repaid if the debt is extinguished according to the agreement. A mortgage is an example of a proprietary type of security, common for supporting loans given by banks to retail customers in financing the purchase of a family home. A mortgage grants a mortgagee a proprietary right in the property as security for a loan, so that the mortgagee may enforce its security by means of sale, repossession, or the appointment of a receiver. The mortgagor, on the other hand, is entitled to recover unencumbered title to the property once the loan is repaid. The essential feature of security over property is that it gives the holder, the creditor, a proprietary claim over the property, asset, to secure payment of the debt. This means that the creditor gets rights which link to the asset and can, therefore, be used against third parties. For example, if the creditor has security over shares, a type of intangible property, the creditor is entitled to receive any dividend which the company pays on those shares. In English law, there is also the possibility of a trust being used as a mechanism to secure a transaction. A trust permits several different people to have distinct rights over the same property simultaneously. A beneficiary under an ordinary express trust has an equitable proprietary interest in the trust property which will continue in full effect even if the trustee or any other beneficiaries go into insolvency. Thus, if a person fears a counterparty's insolvency, then they can have a trust declared over some property. The trust beneficiary is treated preferentially as against some other creditors in insolvency. Trusts require no registration and have no filing requirements. An express trust could be inferred from circumstances, even in relation to a financial transaction. To reiterate, as this is important, the main advantage of taking real security, the one based on property, is that the creditor can rely on his right of preference. This refers to their right to look to the proceeds of sale of the asset to repay the debt in priority to the claims of other creditors, even though the debtor may be insolvent. The second key technique is obtaining some security is the one that relies on contracts. With such contractual security, a lender can always sue on the contract if the debtor does not repay the loan. The obvious problem with this is that if the debtor is insolvent, it is not very efficient to sue them. The problem of the insolvency of the debtor could be addressed through a guarantee provided by a more solvent third party. A guarantee, an obligation that someone else performs the contract, is an additional contractual way of securing a transaction. A guarantee is a promise made by the guarantor to a creditor to honor the performance of the obligations of some other person, the primary debtor, which are owed to that creditor. The main weakness of basing security on a person, such as via a guarantee, is that its value also depends on the continued solvency of the third party, guarantor. If the guarantor becomes insolvent, the creditor has lost his or her security and is in the same position as other unsecured creditors, or those that did not have a guarantee and rely on an insolvent primary debtor to begin with. An important distinction must be made between a guarantee and an indemnity, however. A guarantee is a form of secondary liability in that the guarantor is liable only to make payment if the primary debtor would have been liable to make that payment and has failed to do so. The guarantor therefore only assumes the obligation of the primary debtor when they are in default. A guarantee must be made in writing to satisfy the Statute of Frauds 1677. If it is not in writing, it is not binding. An indemnity, on the other hand, is a promise to make good any loss which the creditor suffers under a transaction whether the primary debtor would have been liable to make a payment in relation to that loss. It is in effect the loss that is being compensated and not the primary debtor's failure to perform some obligation. An indemnity will be a primary obligation, meaning that the creditor can seek to enforce it whenever they have suffered some loss and do not need to attempt to recover from the primary debtor first, as would be the case with the guarantee discussed above. We should note that the guarantor does not have to be a party to the contract between the creditor and the principal debtor. The contract under which primary obligations arise is between the creditor and principal debtor only. There is also a difference between a discrete and a continuing guarantee. Under a discrete guarantee, ANA would guarantee Anacon Limited's liability under a specific transaction or series of transactions. A continuing guarantee covers a flow of transactions under a facility or master agreement. Let us have a look at some examples. If London Bank lends £1,000 to Anacon Limited on terms that Anacon is to repay the principal and interest in a year's time, and ANA guarantees Anacon's obligations, ANA has entered into a discrete guarantee. If Anacon Limited defaults, ANA is liable for £1,000 together with any interest due. If Anacon pays off the £1,000 together with interest, London Bank and Anacon are no longer in a debtor-creditor relationship. Therefore, ANA's liability under the guarantee is extinguished. Similarly, if Anacon buys goods on hire purchase from London Shop on terms that Anacon will pay for the goods by 6 monthly instalments of £100 each and ANA guarantees Anacon's obligations, ANA has entered into a discrete guarantee. If Anacon makes 2 monthly payments and then defaults, ANA is liable for £400, the outstanding instalments. On the other hand, an example of a continuing guarantee would be the guaranteeing of a bank overdraft. Suppose London Bank grants Anacon Limited an overdraft facility of £10,000 and ANA guarantees Anacon Limited's obligations. In this case, ANA's liability is not fixed but fluctuates according to Anacon's outstanding indebtedness to the bank. If Anacon pays money into the overdrawn account, ANA's liability is not extinguished for good since Anacon may then make further withdrawals within the overdraft facility. Contrast this with a case whereby a guarantor can still claim an indemnity or subrogation, but due to the carelessness of the creditor there is some loss to the guarantor. For example, assume London Bank lends £1 million to Anacon Limited. The loan is secured by a mortgage over the company's property. ANA, the director of the company, guarantees the loan. Suppose Anacon Limited defaults on the loan and the bank repossesses the property and sells it at auction. Let us assume that due to the negligence of the bank on the day of the auction, the property only reaches £500,000, when it could have received bids up to £750,000. This could happen when the reserve price at the auction has been set too low. The bank will now look to the director guarantor for the £500,000 shortfall. The director has not been stopped from seeking an indemnity or subrogation by the bank's actions, therefore she is not entitled to be released in full of her liability. However, the bank's carelessness has effectively cost the director £250,000. The director should be released from that part of her guarantee. To deal with these issues, most contracts of guarantee will contain a term whereby the guarantor agrees that any variation in the terms of the contract between the creditor and principal debtor will not discharge or reduce the liability of the guarantor. A different contractual technique is that involving a retention of title clause. See Aluminium Industry Vasen BVV Romal per Aluminium from 1976 and the discussion later on in this lecture. You may also come across the concept of a letter of comfort. Such a letter is not a guarantee, but a note given usually by a parent company suggesting that one of its subsidiaries is expected to be able to meet its obligations. It offers no legal protection but has reputational value. Finally, the packaging and selling of debts as another product, known as the process of securitization, is also a form of insurance commonly used in financial market operations. It works by passing on the burden of default of the underlying asset to someone else who agrees to purchase the bundle of obligations being securitized. We will now look at some further detail some of the rights over property that can be used as mechanism to secure a loan or an investment. We already saw that a mortgage grants a mortgagee a proprietary right in property as security for a loan. A charge, on the other hand, which may be fixed or floating, provides the chargee with a contingent right to seize property if the charger fails to perform its obligations on an underlying contract, and then seeks the order of the court to permit sale. While a mortgage grants a proprietary right, therefore, the charge only creates a right to apply for judicially ordered sale of property if the underlying contractual obligation is not performed. Registered charges, such as floating and fixed charges, are common forms of obtaining security. Charges, as opposed to mortgages, take effect only in equity. Just to remind you, the law of equity used to be a different stream of law in England, derived from the discretionary powers of the Crown to alter the decisions of the common law courts. As this practice was long-standing and consistent, it developed its own jurisprudence which run in parallel to the normal court and legal system, the common law. Equity was concerned with achieving just outcomes, while the common law was concerned with achieving consistent outcomes. At the end of the Victorian era, the two streams of jurisprudence came together, and now the courts can apply both common law and equitable rules in reaching decisions. This is why you will often come across references to equity or equitable principles in many decisions. A charge has been defined as a security whereby real or personal property is apportioned for the discharge of a debt or other obligation, but which does not pass either an absolute of a special property in the subject of the security to the creditor, nor any of right to possession, but only a right of realization by judicial process in case of non-payment of the debt. A charge which is created by way of deed will grant the charge a power of sale once the mortgage money has become due. An equitable charge which is not an equitable mortgage is said to be created when property is expressly or constructively made liable, or specially appropriated, to the discharge of a debt or some other obligation, and confers on the chargee a right of realization by judicial process, that is to say, by the appointment of a receiver or an order for sale. See Re George Inglefield Limited from 1933. Let us look into the distinctions between the different types of charges. The purpose of a fixed charge is to secure a right for the secured party to be paid an amount of money, such that if the money is not paid, then the charge can apply to the court for permission for a sale of the charged property. A fixed charge takes effect over identified property and is limited to that property. The difference between a charge of trust is that the rights of a beneficiary under a trust cannot simply be expunged by the payment of a debt, whereas this is precisely what happens under a mortgage or charge. The charged property, of course, needs to be sufficiently identifiable. A floating charge, on the other hand, comes into existence by virtue of some contractual provision which grants the charge rights of a given value over a fund of property which is greater in size than that right, or which contains property the identity of which may change from time to time. A floating charge crystallizes at the time identified in the terms of the charge itself. Crystallization is the moment in time at which the chargee's rights change from being contingent rights over fluctuating property into rights of a contractually identified value over identified property. At crystallization, the party can take possession of part of the charged property. The whole point of a floating charge is that the charger can deal at will with the property subject to the charge without the need to obtain permissions for transactions. It is a flexible security mechanism favored by banks. We have already mentioned that charges need to be registered to be in effect. The process of registration is explained in the Companies Act 2006, Section 860. A company that creates a charge to which this section applies must deliver the prescribed particulars of the charge, together with the instrument, if any, by which the charge is created or evidenced, to the registrar for registration before the end of the period allowed for registration. There are also some other types of quasi-security that businesses use. One example is contractual set-off, a common device in business contracts. Essentially, the contract provides that if Alpha owes money to Beta, Alpha may set off against what it owes Beta any money owed to Alpha by Beta. Suppose, for example, that Anna, the managing director of Anacon Limited, had guaranteed a loan by London Bank plc to Anacon. Suppose also that Anna had a deposit account with London Bank in which there was a credit balance, meaning that the bank owes Anna that amount. The contract of guarantee between the bank and Anna could, and usually would, contain a clause permitting the bank to take out of the deposit account any sum which the managing director may owe the bank under the contract of guarantee. The crucial point from the perspective of security is that this gives no right over the creditor's, bank's, asset, the debt owed under the guarantee. It is merely a right to set off one personal obligation, by the bank to pay the money in the deposit account, against another, the obligation of the managing director to pay the bank. However, it acts as a form of security because Anna will not want the bank to take out money from her deposit account, so she will pay the bank what she owes under the contract of guarantee. Another example is a subordination agreement. A subordination agreement is an arrangement where a creditor voluntarily agrees to defer his or her right of payment in favor of another creditor. For example, suppose London Bank plc lends Anacon Limited £250,000 to expand its business, and then Canterbury Bank plc lends Anacon a further £100,000. Canterbury Bank will usually seek an agreement from London Bank that they will not enforce repayment of their loan of £250,000 until Canterbury has been paid in full. Banks are sometimes prepared to subordinate their loans to another bank where, for example, there is a long-standing relationship with the first bank and the further borrowing is only short-term. By this contractual arrangement, the loan by Canterbury becomes the senior debt and that of London Bank is subordinated, relegated, to it. No question of security arises because it is simply a contractual arrangement between the two banks as to the priority of repayment. One can also look into the flawed assets. A flawed asset arrangement is the name given to an arrangement where restrictions are placed on a company's right to withdraw money from its deposit account. Remember that a deposit account is an arrangement where the bank is contractually obliged to repay the money to the customer. It is therefore an asset of the customer, money that the customer is owed. So, for example, suppose that Anacon Limited had a deposit account with London Bank. The parties could agree that Anacon could not withdraw sums from that deposit account whilst another company associated with Anacon owed the bank money. The bank has no rights over the credit balance in the deposit account, so it has no security properly so called. The agreement merely qualifies the bank's obligation to repay the money in the deposit account. However, Anacon's deposit account is subject to a restriction on when it can demand repayment, so is in a sense, flawed. The effect, however, is to ensure that the bank gets the money that it has lent to Anacon's associated company. Finally, we can look at a negative pledge. A negative pledge is usually a term in a mortgage whereby the borrower agrees that it will not, without the consent of the lender, grant any other mortgage or charge over the same security. The charge is the security. The negative pledge clause merely a term of the security agreement. The effect, however, is to ensure that the lender gets paid before any other lenders get rights over the security. A final important method of ensuring that a business gets paid for its work product is via the effective use of retention of title clauses. The way these could be used by our sprinkler inventors, Anna and Yanni, would be as a security mechanism to ensure payment for goods sent to customers. The basic principle of a title retention clause is that the contract of sale provides that the seller shall retain title to the goods, i.e. continue to own them, until the price has been paid in full. See Aluminium Industry Varzin BV vs Romalpa Aluminium Limited from 1976. In other words, the buyer does not get ownership of the goods, although they may get possession of them, until they are paid for. A title retention clause can work well where the goods, or sections of them, remain identifiable. When goods have been mixed with others as part of a manufacturing process, these clauses work less well as to achieve security over resulting products. The clause would require registration as a charge under S. 860 of the Companies Act 2006. See our earlier discussion on fixed and floating charges for further information on this process. Where the goods have been sold on, it becomes difficult, without registering a charge, to lay claim over the proceeds of sale through a retention of title clause. Therefore, if Anacon Limited sold a shipment of water sprinklers and the associated invoice required payment by the end of the calendar month, it would be prudent to insert a retention of title clause in the contract of sale alongside the obligation that the goods are kept separate and identifiable, and with the express permission that Anacon Limited has the right to access the premises of the buyer and retrieve the goods, which remain its property, if the invoice remains unpaid after the end of the month or in case of the insolvency of the buyer. How does the issue of security feature in the discussion on the functions and aims of cryptocurrencies? By security in this context, we do not mean technical security, which is provided through the blockchain infrastructure. What we mean is using cryptocurrencies to protect against the risk of default of a counterparty, or alternatively protecting oneself from the volatility of price in cryptocurrencies. We will first examine the possibility of using cryptocurrencies as a hedge against external default risks or price volatility in markets. Digital tokens such as Bitcoin are already extensively used as insurance against the degrading credit quality of sovereign nations and as a hedge against exchange rate volatility. This explains the dislike of the non-state-controlled nature of shadow currency markets by many world governments. The opinion that there is merit in using crypto as a safe haven investment for hedging purposes is widespread. This is believed even though volatility plays a major role in the digital token domain itself and the fact that crypto value fluctuates wildly at any given time. One could compare tokens such as Bitcoin to gold when looking for hedging instruments. Bitcoin could be regarded as a hedge against geopolitical uncertainty, but current data suggests that it is a lot more responsive to economic policy uncertainty shocks than gold. Nonetheless, findings do not rule out the possibility of using shadow currencies as a partial hedge against economic policy uncertainty shocks. Like gold, digital tokens are increasingly serving a store of value function, and their pricing is a product of demand and supply considerations. From a hedge effectiveness perspective, an investment strategy focused on cryptocurrency portfolio may lead to adequate risk reduction when compared to a risk-adjusted portfolio of traditional debt and equity assets. How about trying to secure investments against the volatility in the price of cryptocurrencies? One option here would be the use of credit default swaps, CDs. This market has historically offered a cost-effective way to make short-term hedges or place bets on an individual issuer's credit. A credit default swap is designed to transfer the credit exposure of financial products between two or more parties. In a CDs transaction, the buyer of the swap makes payments to the swap seller until the maturity date of a contract. In return, the seller agrees that if the debt issuer, borrower, defaults or experiences another specified credit event, the seller will pay the buyer the securities value as well as all interest payments that would have been paid between that time and the securities maturity date. In this context, a credit event is a trigger that causes the buyer's protection to terminate and settle the contract. Credit events are agreed upon when the trade is entered into and a part of the contract. The majority of CDs products specify as triggers insolvency or the failure make a specified payment. Credit default swaps are derivative contracts traded over the counter, OTC, meaning they're non-standardized and not verified by an exchange. They make themselves a highly volatile and speculative market and have been identified as a major contributor to the acceleration of the financial crisis of 2008, with known catastrophic consequences for credit availability on a global level. Even though there isn't a great deal of evidence in their use as hedge for crypto risk, it is possible that as token markets mature, CDs contracts will come to complement the environment of products around crypto. For example, assume there is a CDs that earns £10,000 quarterly payments to ensure a £10 million basket of cryptocurrencies. If the company that originally sold the CDs believes that the credit quality of the borrower has improved and the CDs payments are too high, they could sell the rights to those payments and the obligations to another buyer and potentially make a profit. Alternatively, if an investor believes that a company is likely to default on its obligations, the investor can buy CDs from a bank that will pay out the value of that debt if the company defaults. A CDs can be purchased even if the buyer does not own the debt itself. This is a bit like a neighbor buying a CDs on another home in her neighborhood because she knows that the owner is out of work and may default on their mortgage. CDs contracts that reference cryptocurrencies could be used as a speculative investment tool, or as insurance against price fluctuations on the baskets of tokens themselves. Whether any of this is a good idea, of course, depends on each investor's risk appetite and level of comfort in operating in these markets. In this episode, we focused on issues relevant to obtaining security in investments. We discussed the meaning of security in financial transactions and the methods via one may obtain it. We explained the function of quasi-proprietary rights and how they can serve to secure a loan or ensure the repayment of some debt. We also discussed guarantees, indemnities, and other contractual mechanisms such as retention of title clauses. We concluded with a reflection on cryptocurrencies as security mechanisms and on what could be used to secure against the volatility in the price of cryptocurrencies themselves. Thank you for listening till the end of the episode. I hope you are looking forward to the next episode where we talk about issues relevant to international taxation regimes, payments, and efforts to combat money laundering. We start with a presentation of the evolution of a system of global cooperation on tax issues. This is significant even for small to medium-sized investors, such as Anna and Conrad in our scenario. We then explain the operation of payment systems, especially as they relate to international money transfers. This issue leads to a necessary discussion on measures to prevent money laundering, as these have become pervasive requirements for anyone involved in finance and commerce. Without further delay, let us get started on the content of this episode, which focuses on issues relevant to international taxation regimes, payments, and efforts to combat money laundering. We start with a presentation of the evolution of a system of global cooperation on tax issues. This is significant even for small to medium-sized investors. We then explain the operation of payment systems, especially as they relate to international money transfers. This issue leads to a necessary discussion on measures to prevent money laundering, as these have become pervasive requirements for anyone involved in finance and commerce. International tax law is a term that can be used to describe the rules and principles that together regulate the taxation consequences for individuals and businesses that enter cross-border transactions. There is no universal tax law jurisdiction or all-encompassing set of rules, however, and the rules and principles that many nation-states apply when drafting their domestic rules and negotiating their many double taxation agreements are part of each nation-state's domestic tax regime. Countries are constrained by the international tax rules they adopt, and there is a network of over 2,000 bilateral tax treaties that contain definable principles that underlie the treaties and are common to many of them. There is also growing cooperation and coordination of tax policies and rules across countries with disparate tax systems. The OECD, Organization for Economic Cooperation and Development, and the OECD G20 have had a great influence on international tax law by preparing a model double tax convention, MTC, that they agreed to adopt. This has been supplemented by work by the OECD G20 on the issue of base erosion and profit shifting, BEPS. This was the problem of companies shifting profits to countries where they would be taxed more lightly. This initiative now constitutes soft law in that it is not legally binding. However, there is an expectation that the BEPS outputs will be implemented by those countries that participate in the process. There are 4 minimum standards: preventing treaty shopping, country-by-country reporting, fighting harmful tax competition, and improving dispute resolution, contained within the BEPS actions, and together these constitute areas where all OECD G20 countries have committed act. Other areas considered in the BEPS actions, such as hybrid mismatch arrangements and best practice in interest deductibility, have resulted in countries agreeing to act in a similar general policy direction as opposed to agreeing to a baseline standard. The OECD anticipates that over time the tax regimes of countries will begin to converge in relation to these more general policy areas, and that it is possible that these areas may then also constitute minimum standards. As each nation-state determines its own tax regime, the movement of people and investment across borders creates the potential for taxable amounts to fall within the tax reach of only one nation-state, within the tax reach of 2 or more nation-states, or outside of the tax reach of any nation-state. These 3 basic scenarios create problems for nation-states that international cooperation seeks to address. The principles of equity, economic efficiency, and simplicity, which include administrative convenience, are often cited as the 3 major principles that should guide tax policy. These principles are difficult to define and are best regarded as starting points for the discussion of the nature of a tax and providing criteria to judge whether a tax is effective. Equity requires that taxes are levied fairly across society. This notion of society has traditionally envisaged a national society. Ability to pay is often referenced as a measure of the equity of a tax or tax regime. Generally, it has focused on horizontal equity. Taxpayers in similar situations should receive similar tax treatment, i.e., taxpayers that derive the same amount of income should be taxed in the same way, and vertical equity. Taxpayers should be separated according to their level of income, with the result that taxpayers in different situations should be treated differently, i.e., progressive taxation. Economic efficiency requires that tax is imposed in a manner that least interferes with wealth creation. Traditionally, neutrality was a virtue to be aspired to. Taxes should try not to interfere with commercial decisions. The perfect market hypothesis stipulates that markets, left to themselves, bring about optimally efficient outcomes. There are, however, numerous examples of taxes that seek to encourage, e.g., research and development tax credits, or discourage, environmental taxes, certain types of behavior or activity. In contradistinction to neutrality, where markets are shown to fail, taxes can perform a regulatory function whereby they can neutralize or correct negative externalities. Simplicity is a derivative principle that includes several other, sensible, ideas, such as comprehensibility, visibility, transparency, certainty, effectiveness, coherency, consistency, and administrative convenience. Administrative convenience requires that taxpayers are subject to rules that are easy to understand and apply, and that governments bring in rules that can be implemented with as little waste of resources as possible. There is no perfect tax. A tax may be equitable between taxpayers but require much public administration. Another tax may be easy to collect but is not transparent and may be regressive. Taxes are often classified into various categories based on their nature or the object of their focus, e.g., gift taxes attached to transfer of gifts from one person to another. References to international tax in this course are references to taxes on income and on capital gains. In terms of the need to ensure that inbound and outbound investment decisions are not negatively affected by domestic tax rules, a good example of a restricted form of tax sovereignty is evidenced by the European Union, EU. Although the EU provides a good example of constraints placed on tax sovereignty, governments around the world recognize that in a globalized world where both people and capital are highly mobile, it is difficult, if not impossible, simultaneously to ensure capital is invested efficiently in their economies, and ensure they receive a fair proportion of the tax due on overseas placement of its subjects and their investments. It can be said that governments have been ceding their tax sovereignty on a case-by-case basis or need-to-cede basis. In effect, this means that wherever the potential advantages of ceding an aspect of tax sovereignty outweighs the disadvantages of ceding that aspect of tax sovereignty, governments determine that such a ceding is worthwhile and vice versa. The term jurisdiction to tax refers to the tax reach of a given nation-state. In other words, the extent to which a nation-state includes amounts of income in its tax base when these amounts cross jurisdictional or territorial borders. In relation to direct taxation, traditionally there has been agreement surrounding some fundamental aspects of the nature of the jurisdiction to tax. This agreement involves a nation-state being able to include within its tax base certain types of income without reproach from other nation-states. Specifically, this means the acceptance that other nation-states will include the following within their tax base: income of persons who are residents of their state, irrespective of the location of the source of that income. Income of persons who are not residents of their nation-states but who are present or do business in their nation-state where that income is derived from activity or investment in their nation-state. The existence of an agreed core set of principles relating to the jurisdictional extension of a nation-state's tax reach has provided some certainty for taxpayers and governments alike. These principles can be described as connecting factors in that a person, an activity, some property or an amount of income is considered to have some form of connection with a particular state. The connection must be sufficiently strong to justify an assertion of their jurisdiction to tax in one of the three categories. However, different states have different rules as to the various connecting factors. For example, an individual may be regarded under UK law as being resident and thus taxable in the UK but simultaneously resident and thus taxable in Greece. These rules are not coordinated. Thus, there is potential for more than one state to assert its jurisdiction to tax over an amount of income falling within one of the above categories, jurisdictional overlap. There is also potential for two or more sets of domestic rules to operate in such a way that an amount of income falls outside the above categories, jurisdictional vacuum. This is primarily because although there is agreement that states may assert their jurisdiction to tax in relation to the above three categories of income, there is no requirement that nation-states adopt rules in this way. In other words, there is no formal requirement of a minimum level of taxation. This means that it is possible that certain amounts of income that cross national borders may escape taxation altogether. A further related concern arises from the fact that even when the appropriate principles are applied in a context involving two or more states, the principles may operate in such a way as to disadvantage one state over another. For example, nation-states have different levels of economic strength, and where two or more nation-states determine to divide up the tax take relating to income that arises because of international activity, there is the potential for the stronger or wealthier nation-state to resolve to reduce the instances of double taxation in such a way that works to its advantage but to the disadvantage of the other nation-state. This jurisdictional imbalance forms the basis of the notion of inter-nation inequity. Where, for example, two or more nation-states assert their jurisdiction to tax in a manner consistent with the above-mentioned principles, taxpayers who satisfy one or more of the principles in more than one jurisdiction may be subject to the claims of more than one jurisdiction. Let's consider the following example. If Anna is a resident under the tax law of Greece and works as a consultant. She is contracted to supervise a project in the UK. Imagine Anna earns €50,000 in Greece and €25,000 in the UK. If Greece subjects to tax all the income of its residents, wherever that income arises, Anna will be taxed on her total income of €75,000. If the UK taxes all income derived in its jurisdiction irrespective of the residence of the person that derives the income, Anna would be liable to tax on €25,000 in the UK. The effect of this for Anna is that she must pay tax on the €25,000 in both Greece and the UK. If Anna had earned the additional €25,000 in Greece, as opposed to the UK, she would only have been subject to tax on that €25,000 in Greece. Accordingly, by working in the UK, Anna is worse off. This is referred to as juridical double taxation. Both countries consider that they have jurisdiction to tax Anna's €25,000. Greece considers that it can tax the 25,000 as Anna is a resident and subject to tax on a worldwide basis, and the UK considers it can tax the 25,000 as the income has a UK source. We are assuming here no tax cooperation between the two countries. By changing the facts, we can see that Anna could be in an even more onerous position with respect to jurisdictional overlap. Imagine that the rules as to what constitutes residence differ in Greece and the UK. As a result, Anna is treated by both countries as being a resident under their domestic law. This could be because Anna spends a long time working in London but has her home in Athens. Also imagine that both countries use the worldwide basis of taxation. If Anna is treated as being a resident in both countries and because both countries use a worldwide basis of taxation, Anna is subject to taxation on the full €75,000 in both countries. This is potentially a very onerous position, and again Anna is potentially worse off because she has decided to travel overseas, stay there and work. Of course, inconsistencies in tax rules can also present opportunities for taxpayers. A real-life example was Italy in the 1970s. Italian companies were taxed according to their place of incorporation, while in the UK companies were taxed where their central management and control was cited. Accordingly, Italian companies would incorporate in the UK but control their companies from Italy. In this way, they managed to avoid tax in both the UK and Italy. Both the UK and Italy changed their laws to address this problem. The cases of multinational companies such as Apple, Google and Amazon have brought this ability to fall within a jurisdictional tax vacuum to the public attention in the modern context. We will see throughout the course that the issue of jurisdictional vacuum has become so well publicized that both governments around the world and supranational organizations such as the OECD have seen fit to focus significant resources and time on ensuring that taxpayers engaged in cross-border activity have fewer and fewer opportunities to operate within a jurisdictional vacuum. This is particularly true of the G20 and OECD's base erosion and profit-shifting initiatives. Recently, there has been an increased focus on the desperate need for there to be not only a fair amount of tax paid by international operators overall, but also that nation-states with weaker economies need to ensure that they are not being deprived of their fair share of tax revenue. This issue has recently received more attention due to the recognition that nation-states with weaker economies desperately need to be able to generate their own revenue to ensure their continued development, and all nation-states are seeking to protect their taxes post the global financial crisis. In particular, the concept of double taxation emerged through the work of the OECD, G20 in relation to hybrid mismatches. Hybrid mismatches involve arrangements that exploit differences in the tax treatment of instruments, entities and transfers between two or more countries, e.g., hybrid entities, dual residence companies and hybrid instruments and transfers. The OECD has focused on instances of unintended, double non-taxation, i.e., where countries do not intentionally structure their tax systems in a way that results in no tax liability. These instances exclude situations where the relevant country has determined to provide for special tax concessions, such as tax-exempt savings vehicles or a specified personal allowance. Nation-states frequently use similar types of connecting factors to demarcate their jurisdiction to tax. States adopt rules that assert their jurisdiction to tax in relation to a personal attachment to a particular nation-state, nationality, and to an economic attachment to a particular nation-state, origin or source of income generation. The adoption of these types of principles by different nation-states can result in suboptimal situations for both taxpayers and governments alike. Many countries incorporate methods of relief from double taxation in the domestic tax regimes, which does away with the need to allocate the rights to tax amounts to one nation-state or another. However, there is also a large network of double tax agreements, DTAs, which are treaties entered into by two nation-states that allocate the rights to tax certain amounts in a legally binding context. When we talk about allocating taxing jurisdiction, we necessarily must consider a scenario with more than one nation-state in which a taxpayer who is considered to have sufficient connecting factors with more than one of those nation-states is subject to taxation under both nation-states' domestic tax regimes. When this happens, the allocation of taxing jurisdiction function of the DTA looks to the type of income generated by the person and considers which nation-state has the primary right to tax the income, primary jurisdiction to tax, and which has the secondary right to tax the income, secondary jurisdiction to tax. From a practical perspective, it is difficult for a nation-state to assert an unlimited jurisdiction to tax in an overseas context, because it does not have the ability to collect tax when the taxpayer is overseas or because it does not have information about the activity taking place outside of its jurisdiction. There also can be issues in a bankruptcy or liquidation where one of the creditors is a fiscal authority. In these circumstances, the courts will allow the proceedings to continue, as to stop them would be to prejudice the ordinary creditors. Primary jurisdiction to tax is asserted by a nation when it claims the right to tax income irrespective of the jurisdictional claims of other nations. Obviously, if double taxation is to be avoided, each instance of income should be subject to the primary jurisdiction of only one nation-state. A claim of primary tax jurisdiction involves a nation-state asserting its economic connection with the relevant taxable amount of income and so asserting its primary right to tax that amount. Such a situation may or may not result in double taxation. Economic relationship-based claims are treated as primary, as the claiming state, i.e., source state, will be in a stronger position to assert its jurisdiction to tax than another state which has, for example, a personal connection with the same taxable amount. The principle that expresses this economic connection is referred to as the source principle. In other words, where a nation-state can demonstrate that an amount of income originated within its national borders, then it can claim taxing jurisdiction over the relevant amount because the amount has a source within its national borders. Secondary jurisdiction is claimed by a nation when it asserts the right to tax a person that falls within its definition of resident for tax purposes but allows the taxpayer a foreign tax credit to the extent that the income in question is taxed by another nation based on an economic relationship. Personal relationship-based claims are treated as secondary. The state that can claim a taxable amount is personally connected with its jurisdiction will be in a weaker position when asserting its jurisdiction to tax than another nation-state which has an economic connection with the same taxable income. Once our inventors, Anna and Conrad, get going with the production of their water sprinklers and engage in commercial activity, how will the earnings reach them? Any commercial transaction will have two objectives: the supply of goods or services and the payment for those. Payment must be made in the way stipulated by the contract. This will often be in money or via a check. If payment is agreed to be made by check, it is only complete when the check is honored by the payer's bank. Until that time, payment is conditional and the duty to pay will revive if the check is not honored. The main issue therefore will be what method of payment do the parties prefer. If the customer wishes to use another method from the one expected by Anna and Conrad, it will not be effective unless ratified by them. The transfer of money can be undertaken in several different ways. The most familiar method is by the physical delivery of cash to the seller of the goods. The transfer of money can also be undertaken by the physical delivery of a negotiable instrument, such as a check or bill of exchange, to the seller. This may involve some formalities, such as endorsement. The holder of a negotiable instrument obtains good title if they have given value and had no notice of any defects in the title of the person delivering the instrument. Remember that a negotiable instrument is not money, rather it constitutes an entitlement to demand payment from another party. Note that in the UK most checks are crossed, account payee, and are not transferable and, therefore, not negotiable, but are valid only between the parties to the check. It is more likely, however, that payment will be made by a direct transfer from the customer's bank to the seller's bank. The main methods of interbank transfer in the UK are CHAPS, Clearinghouse Automated Payment System, for high-value electronic credit transfers, BACS, Bankers Automated Clearing System, for low-value electronic debit and credit transfers and faster payments, with SWIFT, Society for Worldwide Interbank Financial Telecommunications, being the norm for cross-border transactions worldwide, and SEPA, Single Euro Payments Area, in euros. SEPA operates under Target, Trans-European Automated Real-Time Gross Settlement Express Target System, run by the European Central Bank and facilitates euro transfers. The main UK clearing systems, which, although separate companies, operate under the Association for Payment Clearing Systems, APACS. There are other non-APACS clearing systems, most notably those operated by the Visa and MasterCard credit card providers. Cheque bank transfer should be the most secure method, although no method is entirely safe from fraud. Where there is a funds transfer, the order by the customer to their bank to make the payment does not give rise to a right of the seller against the customer's bank if the bank fails to observe the customer's mandate. The payment by the customer's bank to the seller will discharge the debt owed by the customer to the seller because it is made on the authority of the customer. A payment, even if routed through banking channels, requires an authorized acceptance by or on behalf of the seller before it is complete. Where payment is made through a bank, it will be achieved by an adjustment of the balance of the account of the customer, in this case, which is debited, and of the seller of the goods, which is credited. This process is initiated by the payer issuing an instruction, which the bank, normally, must observe. The debt owed by the bank to the customer is reduced, unless the account is overdrawn, in which case the customer's liability to the bank is increased, and the debt owed to the seller increased, or, if the account was overdrawn, the seller's liability is reduced. The payment by the bank discharges the debt owed by the customer to the seller. Neither credit transfers nor debit transfers are negotiable instruments, apart from checks, but even a check will not normally be negotiable. Bills of Exchange Act 1882. The mechanism for effecting a bank transfer can be illustrated as follows. Zenon Bank makes a payment of £100 in cash or by cheque or other form of funds transferred to Yardle Bank. Zenon and Yardle will both have accounts at the Bank of England, the UK's central bank, so an instruction can be issued by Zenon to debit its account at the Bank of England and credit Yardle's account with £100. It could also be that Zenon and Yardle both have accounts with another commercial bank and agree to settle through that bank. A payment in a foreign currency will usually pass through the central bank of the relevant country, even if the payer and payee are not in the country. For example, a payment in US dollars by a customer in Athens to a seller in London will normally be settled at the Federal Reserve Bank of New York. It is likely that Zenon and Yardle will have several payments between them because they will have a large number of customers, so the payments due to Yardle from Zenon will be set off against the payments due from Zenon to Yardle and the balance debited and credited through accounts at the Bank of England. Settlement may be either on the day the payment is made, same-day funds, or the following day, next-day funds. Some methods of transfer restrict netting. CHAPS, Clearinghouse Automated Payment System, for instance, is designed to achieve rapid payment, so payment is made gross, although where there is a queue of payments in the system it may be possible to net them. As has been mentioned, net settlement may be bilateral or multilateral. In bilateral, netting settlement is between the two banks. Multilateral netting is a system of pooling the debits and credits of several banks. It involves totaling these and reaching a conclusion in which each bank will either be a net debtor or net creditor, or expressing its net position as a plus or minus figure. When the net position of each bank is determined, each transfers into, or receives from, the settlement agent that figure. Despite the sophistication of IT systems and the interconnection of the banking systems, there are still some risks with these transfers one needs to be aware of. If Zenon receives a payment instruction from Yardle for Anna's account, Zenon credits Anna's account and Anna issues an instruction to pay this amount to Conrad at Zoran Bank. If a problem in the settlement system occurs that means Zenon, which is a net creditor at the end of the settlement period, does not receive funds, e.g., because of the failure of Yardle, Zenon will be in difficulty. The problem can be multiplied if Conrad has paid the funds on to other people. Attempts are made by settlement rules to reduce these risks by, for instance, monitoring balances, requiring same-day settlement or placing limits on credit and debit positions of banks, or by switching certain large payments to a real-time gross settlement. Where there is insolvency, the principle of mutuality in insolvency law means that set-off can only be exercised in respect of debts between the same counterparties. This means that the liquidator of an insolvent bank can challenge multilateral netting to the extent that it attempts to set off obligations not entered by the insolvent bank itself. This rule cannot be evaded by an agreement between the parties because such agreements are void for public policy insofar as they avoid the consequences of insolvency law. Settlement will involve a clearing process. While settlement involves payment of funds, clearing is how banks exchange payment instructions. Clearing can be bilateral, between two banks, or, more likely, multilateral, between banks that are members of a clearing system. The clearing system is operated by a clearinghouse. It will deal with paper instructions, e.g., checks, giro transfers, which will involve the physical passing of the paper instruction to the bank on which it is drawn, or, in practice, the clearing department of that bank, and/or electronic instructions, which will be passed electronically through telecommunications links and computers. Different clearing systems have been established to deal with different types of payment instruction. In the UK, banks that are members of the clearing system are called clearing banks, and those that are not members, including overseas banks, will have an arrangement whereby they can pass and receive payment instructions through a clearing bank. If a customer opens an account of a kind which is of a kind into which CHAPS transfers can be made, that customer is entitled to assume that, if a transfer is made for the credit of that account, the bank will operate the account in accordance with the CHAPS rules. Money laundering is the process by which criminally obtained money or other assets, criminal property, are exchanged for clean money or assets with no obvious link to their criminal origins. Money laundering can take many forms, such as handling the proceeds of crime, being directly involved with any criminal or terrorist property, entering arrangements to facilitate the laundering of criminal or terrorist property, investing the proceeds of crime into other financial products or into the acquisition of property and assets. The main UK legislation covering anti-money laundering is the Proceeds of Crime Act 2002 and the Money Laundering, Terrorist Financing and Transfer of Funds, Information on the Payer, Regulations 2017. The Proceeds of Crime Act 2002 sets out the primary offences related to money laundering: concealing, disguising, converting, transferring or removing criminal property from the UK, entering into or becoming involved in an arrangement that facilitates the acquisition, retention, use or control of criminal property by or on behalf of another person, the acquisition, use and/or possession of criminal property, failing to disclose knowledge or suspicion of money laundering to either the nominated officer, where relevant, or the National Crime Agency, tipping off any person that such a disclosure has been made. For the purposes of these offences, criminal property means property of all forms, including, of course, money, which constitutes or represents, in whole or in part, directly or indirectly, a person's benefit from criminal conduct. Criminal conduct is conduct which constitutes an offence in any part of the UK or would do so if the conduct occurred in the UK. If a person obtains what is referred to as a pecuniary advantage, because of or in connection with criminal conduct, they are treated as having obtained a benefit because of or in connection with that criminal conduct. In other words, it is not necessary for a person actively to receive proceeds from an offence for their assets to constitute or represent the benefit of criminal conduct. The savings that a person makes because of tax evasion are, therefore, treated as criminal property, albeit perhaps without there being any specifically identifiable proceeds from that criminal conduct. A person commits an offence if they conceal, disguise, convert or transfer criminal property, or remove criminal property from the UK. Concealing or disguising criminal property includes concealing or disguising its nature, source, location, disposition, movement, ownership or any rights connected with it. The offender must know or suspect that the criminal property represents a benefit from criminal conduct. The prosecution can also rely on circumstantial evidence from which a jury can draw inferences that the defendant had the necessary knowledge or suspicion. It is necessary therefore to prove a. The act of concealing, disguising, etc. b. In relation to property, c. Which was a benefit from criminal conduct, and d. That the defendant knew or suspected that the property represented a benefit from criminal conduct. A person commits an offence if they enter into or become concerned in an arrangement which they know or suspect facilitates the acquisition, retention, use or control of criminal property by or on behalf of another person. To establish a conviction, the prosecution must prove not only that the defendant became concerned in an arrangement which they knew or suspected would make it simpler for another person to acquire, retain, use or control criminal property, but also that the defendant knew or suspected that the property constituted or represented benefit from criminal conduct. The test is whether the arrangement has the effect of facilitating the acquisition, retention, use or control of criminal property by or on behalf of another person. A person commits an offence if they use criminal property or, passively, possess criminal property. This crime is presumably intended to apply to persons who are not necessarily involved in the underlying criminal conduct or subsequent laundering activities, but nonetheless knowingly enjoy the benefits of criminal activity. The prosecution has to prove acquisition, use or possession of property, which was the benefit of criminal conduct, that the defendant had the necessary knowledge or suspicion that the property represented a benefit from criminal conduct. A person will have a defence to the money laundering offences if they make an authorised disclosure prior to the offence being committed and them gaining appropriate consent intend to make an authorised disclosure, but had a reasonable excuse for not doing so, knew or believed that the money laundering was being committed in another jurisdiction and, at the time it occurred, such conduct was lawful under the criminal law then applying in that country or territory. In addition, a person will also have a defence under if they receive adequate consideration for the criminal property. A person commits an offence if they know or suspect, or have reasonable grounds for knowing or suspecting, that another person is engaged in money laundering. The information on which their suspicion is based comes in the course of business in the regulated sector. They fail to disclose that knowledge or suspicion, or reasonable grounds for suspicion, as soon as practicable. Broadly, the regulated sector activities that are covered are accepting deposits, insurance, dealing in investments as principal or agent, arranging deals or investments, managing investments, safeguarding and administering investments, sending dematerialized instructions, establishing collective investment schemes, advising on investments and issuing electronic money. A person does not commit an offense under if they have a reasonable excuse for not disclosing the information, or a professional legal advisor and the information or other matter came to them in privileged circumstances. But notably, this defense does not apply if the information is communicated with the intention of furthering a criminal purpose. They do not know or suspect that another person is engaged in money laundering, have not been provided by their employer with such training as is specified by the Secretary of State, knew or believed that the money laundering was being committed in another jurisdiction and, at the time it occurred, such conduct was lawful under the criminal law then applying in that country or territory. Notably, legislation uses an objective test and thereby effectively criminalizes negligence in the regulated sector. Thus, if an individual employed in the regulated sector fails to detect or suspect that a suspicious person is engaged in money laundering activities, but, then, a court determines that objectively, in the given circumstances, they should have done so, that individual, and consequently the firm, may be guilty of a criminal offense punishable by a fine and up to 5 years imprisonment. In this episode, we focused on a series of issues relating to taxation and international money transfers, starting with the evolution of a system of global cooperation on tax issues. We then explained the operation of payment systems, especially as they relate to international money transfers. This led to a necessary discussion on measures to prevent money laundering, as these have become pervasive requirements for anyone involved in finance and commerce. Thank you for listening till the end of the episode. I hope you enjoyed this green series of podcasts and you will return to this channel for more.